Right, good morning. I would like to call to order this public hearing on the Committee on the Judiciary and Public Safety. I am Councilmember Brooke Pinto, representing Ward 2 and Chairwoman of the committee. It is 10:17 a.m. on Thursday, May 30th, 2024. We are conducting this hearing in person in room 123 of the John A. Wilson Building and streaming on the DC Council's website and YouTube and X at @CM Brooke Pinto. On the agenda for today is Bill 25-791, the Utilizing Partnerships and Local Interventions for Truancy and Safety Amendment Act of 2024, otherwise known as the UPLIFT Act. This hearing will specifically focus on the first three titles of the bill, which pertain to limitations on prosecutorial tools when charging juveniles who have committed certain violent crimes. This hearing will not review the bill in its entirety or the provisions related to truancy, which will be done by the Committee of the Whole. UPLIFT was introduced by Mayor Bowser on April 11th, 2024. For this bill, the committee only received referral for the first three titles, otherwise known as sections of the bill, because they deal with the criminal justice system and specifically prosecution. The remainder of the bill addresses truancy issues and are referred to the Committee of the Whole, which oversees education. As a procedural note for those listening, the referral process is done through the chairman's office, and bills either in whole or in part are referred to different committees based on their subject matter. While we're only specifically dealing with the criminal justice related pieces of the bill in this committee, the context of the larger purpose and challenges the city is facing in regards to truancy is relevant. We have seen major increases in unexcused absences in our schools these past several years, with over 1/3 of our kids being chronically truant or absent. And so it's really important as we consider these titles of the bill that we understand our entire ecosystem needs to do a much better job of serving kids and ensuring they are in school. Title 1 of the bill would require the parents of youth charged with a dangerous crime while armed or charged with a crime of violence to participate in a conference to develop a family rehabilitation plan and determine what services the family needs. It also requires DYRS to complete an assessment of the youth's needs and the family's needs based on the conference. Title 2 of the bill would bar youth charged with a dangerous crime while armed from benefiting from the adjustment process during a case. The adjustment process allows for a case to be eligible for some type of diversion instead of a delinquency petition being filed to formally charge and prosecute the juvenile. Title 3 of the bill would bar youth charged with a dangerous crime while armed or crime of violence from benefiting from consent decrees, deferred adjudication agreements, and deferred disposition agreements. These mechanisms are tools that OAG and the courts utilize to limit a youth's exposure to the criminal justice system and provide an opportunity for the youth offender to comply with certain conditions and supervision while avoiding a permanent criminal record. There has been a recent increase in violent crimes committed by our youth in the district. Just last month, a group of teenagers were fighting in Brookland Metro Station when one of the teenagers pulled out a gun, shot, and killed another teenager. The victim was only 14 years old. These acts of violence, particularly those among our youth, are not only tragic for the young people involved, but they permeate throughout our communities. We must do better to support our youth and keep them safe. In fiscal year 2023, there were 2,001 juvenile cases presented to the Office of the Attorney General. The Office of the Attorney General, or OAG, as the prosecuting agency for the district for most crimes committed by youth, is an important partner in addressing recent increases in juvenile crime. Of the 2001 cases, OAG papered roughly 53% of the cases that were brought to them. Of these cases, OAG has a papering rate of 88% for murder, attempted murder, or manslaughter, and 81% for gun prosecution crimes. Another issue is recidivism rates, where youth who are either charged or convicted of a crime go on to commit subsequent offenses. According to OAG's responses to the performance oversight questions in February, for youth who had a juvenile matter opened with OAG, 30% of these youth generated a subsequent matter before OAG within the year. When youth were prosecuted by OAG, 39% of these youth were prosecuted for a subsequent offense within 1 year. But alternatively, when they were diverted through one of the diversion mechanisms, only 27% of youth reoffended within 1 year, while 44% of youth who were prosecuted reoffended within the year. So on their face, these numbers appear to show that diversion can result in reduced recidivism rates. I look forward to hearing today about the nuances of these statistics, both youth arrest and crime statistics, as well as juvenile recidivism rates. I'm also interested in learning more about how these diversion and alternative charging tools work, their effectiveness, and how the mayor's proposed bill would affect youth outcomes in the criminal justice system. We also need to dive into what happens when a young person does not show up to the diversion program that they qualify for and what the follow-up steps are and should be to ensure that those can be effective. We must stay united in our mission to drive down crime and ensure that the services available to and the responses to our kids are effective and are working in tandem within the context of our larger ecosystem. For today's hearing, we're first going to hear from public witnesses to discuss the bill, first those in person and then those joining us virtually, and then we'll turn to our government witnesses. As is our usual tradition, public witnesses will have 3 minutes to present their testimony, and those representing organizations will have 5 minutes. I would like to now invite our first panel of public witnesses to come up. If I can ask the first person to sit on my right and your left on the table. Chelsea Coffin, Eduardo Ferrer, and Rio Sigala Rio Frio. Okay. Yeah. Yes, this is perfect. Okay. Just to confirm, Chelsea Coffin not here. Rio Sigala Rio Frio not here. Okay. Daria Scala and Cynthia Sitt. Word. Ann Stevens. Go ahead. All right. We will start with Eduardo Ferrer, visiting professor and policy director of the Georgetown Juvenile Justice Clinic and Initiative. Welcome.
Thank you. Thank you for having me. Good morning, Chairperson Pinto and members of the Committee on Judiciary and Public Safety. My name is Eduardo Ferrer. I'm a Ward 5 resident, the policy director at the Georgetown Juvenile Justice Initiative, and a visiting professor at the Georgetown Juvenile Justice Clinic. Thank you for the opportunity to testify today regarding Titles 1 through 3 of Bill 25-0791. Given the time limit and that I have a lot to say about the proposals in Titles 1 through 3, I will supplement my oral testimony today with longer written testimony before the record closes. Starting with Title 1, Title 1 of Bill 25-0791 proposes amending the statute authorizing the court to enter parental participation orders to mandate that the court enter an order requiring both the parents and the youth in select cases participate in a family group conference with DYRS, abide by any services that DYRS deems necessary, and incorporate all of those services into any future probation orders of the court. I urge the committee to reject this proposal for a number of reasons. First, Court Social Services is already conducting family group conferences and delinquency cases shortly after their inception. Typically, within a week or two of being assigned a case, the Court Social Services probation officer sets up a family group conference with the young person and their parents or guardians to discuss the release conditions set by the court and the strengths and needs that the youth possesses. This conference builds upon information collected by CSS and the court during the intake and the initial hearing stage of the case. Based on this conference, probation officers often make referrals to DC agencies and/or service providers in an attempt to connect the child with community-based services. Based on this initial family group conference, probation officers may also request that the court order additional evaluations or that the court appoint an educational attorney to assist the parent in ensuring that their child is receiving the educational supports they need to succeed. Requiring an additional family group conference with DYRS, who at this point in the case has little to no information about the child or family, would not only add little value, it would tax DYRS resources at a time when the agency lacks the capacity to meaningfully and timely create plans for the children already committed to its care. Now is not the time to give DYRS responsibility over more youth. Second, Title I proposes to give a party disconnected from the case authority to develop a plan for a child and family while absolving it of any duty to implement the plan or update the plan as needed. Currently, as part of their pretrial supervision of a youth, CSS probation officers are in regular, often weekly contact with youth and their parents and recommend changes to the release conditions and suggested services as they learn more information about the family and what services they see are or not working. DYRS does not have the same level of involvement in a pretrial case. Instead, pursuant to this proposal, DYRS would parachute in and then parachute out, while the plan they created with little information at the start of a case would control throughout the pendency of a case. This is not an effective way to plan or deliver services to young people. Third, the proposal would usurp the court's power and would prohibit the court itself from updating the service plan based upon information learned from evaluations conducted or experience with the youth and family during the pendency of a case. Again, not an effective way to plan or deliver services. Fourth, the proposal raises significant due process issues. As drafted, Title I does not define a family rehabilitation plan, nor limit the types of services that could be incorporated into a family rehabilitative plan. Moreover, as mentioned, Title I takes away all power from the court to amend such a plan. As such, Title I gives DYRS unfettered authority over a young person and their parent. For example, DYRS could develop a plan that requires inpatient drug treatment or psychiatric treatment for the youth or their parent, implicating their liberty interests, and the court would be compelled to order compliance with those services without any opportunity for the youth or the parent to contest that service plan or to shape that service plan before the court. Similarly, DYRS could develop a service plan based on erroneous or incomplete information, and the child and the parent would be powerless to correct or contest the plan. Finally, based on my experience, where the system is breaking down right now for pretrial youth particularly is not the planning stage or the service plan creation stage, it's at the implementation stage. Court social services is planning and making referrals. We as defense attorneys are planning and making referrals. Parents are planning and making referrals. But community-based services, particularly behavioral health services, are just not consistently available in an accessible, timely, or consistent or effective manner. If we want to improve public safety and outcomes for youth in the delinquency system, we need to focus on and fix access to services. Second, in the last 15 seconds, I'll try and briefly summarize my opposition to Titles 2 and 3. There are really 5 key themes related to these titles. First is I want to make clear that once a case is petitioned, it's the court that sets conditions and court social services supervises a young person until the case ends or a youth is committed to DYRS. This means that CCSD is supervising young people on consent decrees, DPAs, DDAs in the specialty court programs, just as they do a young person who is on probation. Okay, so just because a case doesn't go to disposition doesn't mean the young person isn't receiving the same level of scrutiny, supervision, and services as they would if the case were to proceed to disposition. Second, consent decrees, DPAs, and DDAs are not lesser than probation. Often they actually include conditions or services that are more intense than probation would be. So participation in the specialty programs requires more frequent contacts with the court and more frequent court hearings. DDAs are often conditioned on participation in restorative justice and cognitive behavioral therapy, a much more intensive version from the kid's standpoint of what they would be looking at if they were just placed on probation. Third, kids often take these agreements despite them being more work or greater risk to the young person because they sometimes have to plead to higher charges in order to get the benefit of a DDA because of that benefit. And so it really helps OAG incentivize individualized service plans and responses in cases. Fourth, they help minimize the collateral consequences. And so if a kid does everything,
Mr. Ferrer, I'm
yes.
gonna have to ask you to
Okay.
summarize and wrap up your way over
Sure.
here.
So the last thing I'll say is this notion of collateral consequences, right? If a kid does everything we want them to do, why do we want a conviction on their record that's going to make it harder for them to go to college, get a job, become a police officer or a firefighter, right? That's going to undermine public safety, and that's certainly not what love looks like in public safety or in public policy. Thank you.
Thank you very much. Daria Scala, I have you as a public witness. Are you here on behalf of organization?
I'm here as a public witness
Okay.
on behalf of, well, we're parents from the Mundo Verde bilingual charter school. So
Wonderful.
I will appreciate the extra time, I guess.
I think that usually is still a public witness, but we appreciate
Okay,
you
sure.
you being here. Go ahead.
Thank you. Thank you, dear Councilmember Pinto, and everybody. My name is Darius Scala. I'm a parent and longtime DC resident in Ward 6. I commend your leadership, Councilmember Pinto, and the council's passage of the Secure DC Act, and I support many provisions there. And I understand this bill represents an attempt, a piecemeal attempt, like we heard, to deal with youth accused of violent crime. And I appreciate the focus on the offenders here and what love looks like to the offender. But I want to focus this conversation at least on the community, being part of the community that has experienced a lot of crime. Over the last 2 years, I have personally witnessed multiple shootings, all by young people, around our children's school at Mundo Verde and Truxton Circle. I'm personally afraid to let my school take our children to a playground nearby because it is a known crew zone, and the police feel helpless about this. And this is happening all over the city. My concern is that we're not addressing the root cause of this strategically. And I've talked to multiple DC officers and commanders who, again, feel helpless. They tell me they're arresting the same young adults over and over again. One commander told me that when they pull over a car with 4 teens, they expect to find 4 guns. That's the situation. Rather than feel respect for the justice system, the young offenders feel empowered enough to pick up automatic rifles and have shootouts near our homes and schools to resolve their crew battles. This is completely unacceptable. We know from analysis that 2/3 of the gun violence problem comes down to about 200 to 500 offenders terrorizing our city, mostly young adults. These are folks who have had a lot of, who've touched the system many times. We have another analysis that shows that juveniles committed at 17 and 18 with serious crimes spend much of their time at DC youth rehabilitation centers watching YouTube, playing Grand Theft Auto and Call of Duty. This is unacceptable. I commend the DC Attorney General's recent lawsuit to compel reform of the agency. We have many links throughout the entire system. So I'm here to ask for a full evaluation of the entire system and to put together a strategic plan that is sending the same exact message across the system that we have zero tolerance for gun violence. As soon as someone pulls out a gun in public and starts shooting, that's it. Love, stops there. They're endangering everybody around them. Again, I have had to flee a mass shooting myself from a young person wielding an automatic weapon. They were never caught. And we know what happens to our young people who do get caught. We just heard about this. So I'm really asking you, Ms. Pinto, and everybody else on the council to put together a strategic plan that evaluates everything from the very beginning to the very end to send one straight message: zero gun violence and tolerance of it. Thank you.
Thank you very much, Ms. Scala. Cynthia C., public witness. Am I pronouncing your name correctly? She. Thank you.
Thank you, Councilmember Pinto. This is my first time testifying for a council committee, so I don't have as many specific policy recommendations or asks. I am just here to share my experience as a citizen of DC. So my name is Cynthia Shee. I'm a parent of a pre-K student at Mundo Verde Bilingual Public Charter School. We are recent new residents of DC and proud of it. We're Ward 5 residents. We live in Edgewood, actually quite close to Brooklyn Metro, where the recent fatal shooting that you mentioned took place. We go to that metro station quite often. This is only our first year at Mundo Verde School, but we have fallen in love with the school and the community and being part of DC in that way. I don't know if any of you have ever been there at morning drop-off, but it's a whole party. The music is blasting. The families are pulling up in every form of transportation. The administrators and teachers stand at the door and greet the students by name, hugs and high fives. It's amazing. It's amazing, this community feeling that has been created, not just by the school, but by all the families who are invested in it. And in our first year, we've also experienced a lot of violent incidents just outside the school. My 4-year-old actually now talks about missing playground time because someone dangerous is outside, and none of the kids can go out. She has played pretend at home that she has a dance performance that she's excited about, but oh, they're canceling it because someone is outside with a gun and the police are coming, so we all have to hide. This is part of her play now. She's had a classmate, also a 4-year-old, to say to her face, "I'm going to shoot you with a gun," because these are the things that they experience. It's actually something that they see and they witness and they know about. And this, or worse, is the reality of many preschoolers across our city. So my fellow Mundo Verde parent, Daria, has spoken to some of the specific opportunities we see and we would like to see enacted so we can do better on youth crime and youth rehabilitation in DC. And we are genuinely appreciative of what the council is doing and what we see MPD doing specifically in partnership with our school and I'm sure many other schools across the city. And so I guess I would like to ask today about what are the quick wins that are possible? What would you ask our highly motivated, brilliant group of parents and caregivers to come together to do in partnership with what the council and so many other agencies are doing to really kind of create some sort of success story? We would love to be part of that. We would love to kind of plug into the things that are happening and to really achieve something that would make the whole city say, wait a minute, this school and this community, this neighborhood was able to do something amazing for everyone involved. How can we replicate that across the city? Thank you.
Thank you so much. Thank you for sharing that story. Really heartbreaking. Ann Stevens, public witness.
This is also my first time testifying, so also I'm more kind of speaking here as a citizen in my experience. So first of all, thank you for all the work that the committee has done, council member. I have lived in DC for 17 years, and in the past year, crime, in my opinion, has reached a breaking point that has forced, unfortunately, my family and I to consider moving from the city. A series of events in the past 2 months have made me question the safety, our safety and our willingness to accept the risk of raising my children in Washington, DC. A little over a month ago, I was picking up my 3.5-year-old son, also a pre-K student, at Mundo Verde at North Capitol MP. It was the afternoon of the eclipse, classes had been released, and lots of kids were out front and in side yards playing and watching the eclipse when multiple shots rang out. About 100 or more people ran inside in a panic into the building. It was terrifying. I wanted to sob, but I was surrounded by children as well as my own, and I held it together. But I had to ask myself the entire time after that experience and as we were on lockdown inside the school, if that's how I feel, how does that 8-year-old boy who I don't know, who's sitting in the corner next to me holding his knees feel? How does every other kid inside the building feel? How does it impact their mental health, their development? Less than a month later, I received an alert from the school while I was working. Upon opening the app, I learned that Mundo Verde was on lockdown again. This time, it was the shooting at Dunbar, only 3 blocks away. Everyone in this room has undoubtedly seen the footage. Bullets hit the windows of the school. And again, this made me ask myself, if our kids aren't safe inside the building and they're not safe outside, what message does this send, especially when we talk about issues like truancy? So in the days that followed, I had to ask myself, can I actually send my kid back to school? If something happened to him, would I ever be able to forgive myself? Our children don't make the decision, we do. So parents are now debating all across the city if they can send their child to school or if the time has come to leave the city altogether. I don't want to leave, but I also have to ask myself, again, what would I do if something happened? We also have to assume that teachers and staff are asking themselves the same question. If I was a teacher responsible for a classroom of 20 pre-K students, how would I handle that amount of stress and responsibility? Also knowing that any day I could be walking into the building and something violent could happen to me. I know this is an incredibly complex issue and it needs to be treated with a multifaceted approach. I am fully aware of the constraints that DC faces as a district and not a state. We should argue for statehood. We should pressure the Attorney General's office to increase prosecution rates or be replaced. We should support and fund programs to keep children in school and engaged. And while I fully believe all these tactics are necessary, I also recognize that they will take time. They're necessary, but we cannot expect to see immediate results with these types of policies. time is running out and we need an emergency action to bring the violence to a halt. So my question and ask is, what are we doing to address the the urgent situation that we are facing to advocate for an emergency response? So that is my testimony.
Thank you very much, Ms. Stevens. Thank you all for your testimony, and welcome for, as you mentioned, your first time testifying. And I think that that speaks to the amount of stress and pressure the community is under on this topic. And I really appreciate you being here. I want to ask you three first, as parents. Part of what this bill is suggesting in the first section is to say, when a child is being brought in, is arrested, let's work with the family to understand what is needed. Are there follow-up supports that are needed? How can we make a plan early before the case kind of works its way through the system? And from your perspective, are these incidents that are happening outside of the school related to students who go to Mundo Verde, or just happening in the city generally close by? And what do you think about the kind of parental involvement component here?
Personally, I don't think they relate to the school at all. I mean, I think our kids feel I feel that the school is secure. I think it all relates to these quote unquote crew fights that are happening around the school. And again, I mean, it seems like the issue comes down to a few hundred individuals that are terrorizing the whole city. So to me, to ask, okay, a kid, you're saying a teenager is arrested post, let's say, like a violent crime, the one that we saw shooting his gun at a intersection full of our parents and children, and that now the next step is to make a family rehabilitation plan. I mean, it sounds a little bit more, the focus is, and I'm completely sympathetic as a parent, especially, that these individuals come from very difficult circumstances. No doubt, all of them have had traumatic lives, no doubt. But we're not sending the right message. I don't think we're incentivizing no gun violence. We're incentivizing the opposite. Think of not just the offender, but who is watching the offender and what happens to the offender. The community who is watching this. What message are we sending to this? This is why, I mean, to me, again, how does it all, what is the entire system? And why are we not sending the same exact message, zero tolerance for gun violence throughout that's the message we need to send. So honestly, I'm not sure what that looks like. I don't think it looks like a family rehabilitation plan. I don't think that's what observers of this situation and fellow crew members, if it is a crew situation, what are they thinking? From what I understand, lots of offenders feel like it's a free get out of school card to go to spend time in the Department of Youth Rehabilitation Services, spending it 90% of the time you're watching YouTube videos and playing video games versus going to school. To a teenager, a troubled teenager, this sounds really attractive. We've incentivized. This is what is really, to me, is at the root of the problem. Our system has incentivized this behavior. It's not just accidental. It's not because they're bad kids. No, they're not bad kids, obviously. But they've been incentivized. They're watching this. They're watching what happens to their peers who've pulled out guns, who've terrorized communities. They're hanging out and sitting around and doing something other than school. This is a big plus. So, I don't know, you asked specifically, I don't know what the solution is, but I know this isn't it.
Thank you.
The only thing I would add is, I think it's too late. Like, I think if there's a violent crime that's taken place, the opportunity for family support and intervention, it's too late. That's obviously something that I know not that much about all of the policy and all the systems that take part. That is not my area of expertise. But we did hear from the first testimony that there's already a lot of family involvement that is apparently taking place. And there are requirements and there are the caseworkers working closely with the family and the kids. So if that is already happening, it doesn't seem like this additional element would do anything to deter crime. If anything, that type of intervention needs to happen a lot earlier. In my opinion, I think it's a zero tolerance policy. And this is why I say something along the lines of like, there has to be a very clear message that this type of crime will not be tolerated, because the feedback that we hear kind of anecdotally is that people feel like there are no repercussions. The police share that with us too. We communicate like I email the police every time something happens, and they're very frustrated as well. They see the same people out every time, and these kids don't really seem to care. And so I just don't think it would make much of a difference.
Okay, thank you. So, Mr. Ferrer, on the other hand, you testified that you don't think that these rehabilitation it seemed like you were saying these rehabilitation plans are too aggressive to have DYRS involved at an early stage. And so what is kind of your response to some of this concern that we're hearing of making sure that families have earlier interventions and that the message is very, very clear for kids who are involved in our most dangerous violent crimes? Sorry, your mic.
I want you all to know that I know exactly where you're coming from. My son's school on South Dakota Avenue was locked down twice during his preschool years, right? And as a parent, that's terrifying. I've also lost a lot of young people that I've worked with to gun violence, sadly, at parents with funerals. It's a lot, right? And that's why I'm so committed to making sure that we're getting this right. And I think a couple of elements of that. One is what I hear you saying is prevention. What we want is for harm not to happen in the first place. That's what we want. That happens way before any arrest, right? We know that young people who come into contact with the delinquency system, 12% of them have been homeless, 50% of them have had contact with CFSA, 45% of them have a diagnosed mental health issue. These are agencies that this bill doesn't touch at all. If we want to prevent harm from happening in the first place, that's where the breakdown is happening. That's what I'm talking about. Planning once post-arrest is happening. It takes me forever to get a young person connected to behavioral health services. A kid and a family shouldn't need an attorney that's a squeaky wheel. You know, our students have a lot of time on their hands to work on these cases very individually. They're making phone calls all the time, and it is very difficult to get services right now for young people in the city. If we improve the services, kids will be getting those services before harm happens, and that will also improve our ability to intervene after. The second thing I'll say, and I understand this narrative that kids feel like there's no repercussions, but I think we also have to understand their perspective as well. The clients that I work with, the young people that I work with, I have more honor roll students on my caseload now than I have had in a long time. And it is in large part because they are terrified of being the one who doesn't have a gun. So they're not using guns, they're carrying guns, but they're the ones who are terrified of having a gun if they need it, right? And so you can't deter rational behavior. If my choice, if what society and what my experience has taught me is, my choice is between getting shot or getting arrested, it is totally rational to make the choice of risking getting arrested. And so what we need to be working on is looking again back to the data. We know there are somewhere between 250 to 500 individuals every year, most of them adults, by the way, but 250 to 500 individuals every year who are most at risk of being the victim of gun violence or perpetrating gun violence. We should be intervening upstream with them. But then the piece that's still not in our strategic plan is, how do we shrink that number? Why are we satisfied with intervening with 500 people every year? Why don't we have a plan for making sure that that number next year is 400 people at risk? And the year after that, it's 300 people at risk. If what we want is a healthy, thriving city where everyone feels safe, safety is a byproduct of thriving communities. We have to invest in our communities. We have to invest in our young people and their families directly.
And thank you for that. And I don't disagree that there are a lot of gaps across our system. We're clearly not getting services and wrapping our arms around people and their families soon enough. There is a lot of truth to that. And when we have missed the mark, or what we do today or tomorrow or next month has to also be evaluated, because these investments, and I will do everything I can in working with my colleagues and working with the executive to move us forward in the right
Mhm.
direction. But with this committee and this bill that's before us, we are looking at elements, legislative elements, once it has been too late, once there has been a violent crime. And so while that doesn't make the larger discussion not equally as important and not relevant, it is important to me to make sure that we are focused on also what happens now. And so back to this first title, and if you have other thoughts on the other titles too, when we've missed it,
Mhm.
and when somebody has engaged in a violent crime or has shot somebody or used a gun, what is the challenge, particularly with Title I, of including DYRS as part of that family outreach
Mhm.
to make sure that every step along the way, even if a child is diverted, but then maybe they don't show up to the diversion
Mhm.
program, even if they are committed, but maybe it's for 30 days or 60 days, and then they're back in community, what is the harm of including more players early and being part of that strategic plan?
I think a number of things. One, it's duplicative. So court social services is already doing that planning early on in a case. Second, particularly inserting DYRS at that point, you're inserting a party that has no knowledge of this kid. They have not worked with them at all. They haven't, this will, the family group conference, the way this legislation is drafted, there are no requirements to do any planning, collect any information, none of that. And that's stuff that court social services is already doing. So we're going to be working at cross purposes. Third, DYRS then has no responsibility to implement it. And the reality of it is that's not where the breakdown is happening. As I mentioned, court social services is following through. Court social services is often being a squeaky wheel, trying to get kids services. And the services just aren't there. So it's other district agencies that are falling down on the job. Inserting DYRS into that process isn't going to make DBH, DHS, CFSA, the schools do better. And then lastly, it's that DYRS doesn't have capacity. They're not planning for their own kids. They're not doing a great job supervising their own kids in community. Adding more young people to their caseloads wouldn't be an effective way to get at this issue. So rather than add this other layer of needless, ineffective bureaucracy that also causes due process concerns, let's get at the root of what's actually going on, which is court social services plans, and then DC agencies aren't meeting court social services, the young person, the family, where they need to in order to actually make sure that that plan is implemented successfully. And so Title I isn't going to solve any problems. It's going to create more, and it's going to take our eye off the ball, which is let's make sure these services actually get to young people.
Okay. And I'm kind of over time here, but just last question. There are other sections of this bill that mandate that when certain violent crimes happen, the case cannot be diverted. And so when I hear our parents talk a little bit about like zero tolerance and making sure it's a clear message, is that the type of thing that you are referring to for a commitment for those types of violent cases? And then Mr. Ferrer, if you can respond after they do about if you are aware of any other jurisdiction that kind of limits prosecutorial discretion in that way.
I would just say that I don't know that we necessarily speak with a united voice about this, specificity of policies, but I do think we all feel that we want what works, right? What is actually going to be the experience of a youth who is caught up in these kind of crews or violent crime such that they experience a process that gives them the support they need, but also makes the consequences quite clear. And that the ultimate result is that we have less terrorizing of playgrounds and neighborhoods of our schools and of our families. So I don't know if personally whether zero tolerance is the right answer. I also believe in love in public policy. And I also believe in ensuring that youth who are caught up in some of these behaviors don't become adults who are also continually incentivized in the wrong direction. So I don't know the specificity of that, but I do want to see the people who commit these acts experience something from the system that directs them in the, in the right place.
And if I could just add to that, I mean, I completely agree. I don't think, I mean, I think zero tolerance is the idea of if we have a violent crime like that, that the entire message that gets sent to the community is that this is intolerable for us. What that means and what that looks like is exactly what Cynthia outlined. That means that we have a whole strategy and a system that works, that's streamlined, that works to reinforce this message, help when is needed, right? Assist our vulnerable populations before the crime happens, like we're talking about. When it happens, again, the message is clear, this is intolerable. Of course, we want to prevent, we want to proceed in such a way as to prevent future problems for that individual as much as we can. But we can't be blind to the idea that we're also sending a message to other would-be offenders. That's kind of, to me, I think is the issue, is that when we're only focused on the offender, as of course we need to do, but we're completely shutting out this whole, the image of it. But the image, it's not just image, right? It translates to people's actual actions and the message that is out there on the streets, that this is what we do, right? And that our kids feel the need to carry guns to protect themselves. Why? Because we are having problems dealing with 200 to 500 individuals terrorizing our city. And these aren't unknown individuals. We don't even need to look for them, right? We know who these people are. And I think to Cynthia's point, we're not experts on this, right? But it has to be part of a strategy. This is why this bill is a little bit, to me, it's like, well, they're picking out like one tiny little piece, but the context that you were talking about, what does that look like within the entire context for all the different steps, pre-crime, crime, post-crime, parole, right? What is the overall strategy?
Mr. Ferrer.
Yeah, I think that tees up what I wanted to say perfectly, which is what we want to do is what works, right? And that really is individualization. So reducing the discretion of OAG to individualize a resolution for kid doesn't work. I'll give two quick examples. One is what complainants want, right? Lots of complainants, for them to heal, want to engage in restorative justice. The way that practically happens now is often through a DDA agreement. Restorative justice, not always, but often, right? Restorative justice has to be voluntary. Both parties have to want to do it. Utilizing a DDA incentivizes a young person participating in restorative justice. We'll get a plea offer that's often plea to X charge and agree to do restorative justice and cognitive behavioral therapy, and you can have a DDA. If you reject cognitive behavioral therapy and restorative justice, then we're going to proceed to a plea offer that includes going to probation or going to disposition, so then probation or commitment. And so it incentivizes what the complainant in that individual case wants the outcome to be. And restorative justice is one of the most effective methods we have for kids really learning accountability, having to see the perspective of the person that they caused harm to and finding ways to repair it. And so unduly restricting the ability to offer DDAs would impair that ability to, one, give complainants and victims what they want, but two, also individualize the response to the young person. The second example I'll give is just the breadth of this. Crime of violence includes assault with a deadly weapon. I've represented young people that have been charged with assault with a deadly weapon pair for a food fight that took place in school, assault with a deadly weapon snowball for a snowball fight that happened in the community, assault with a deadly weapon shod foot because they kicked someone in the shins. Okay, all of these cases, these are not kids who had serious violent offenses, but because of the way that they were charged, they would then be falling into a category where they would be prohibited from getting some type of individualized response from OAG. And that ultimately is going to undermine public safety. It's not going to help us foster it. And so what we need are more tools, not fewer, in order to really intervene with young people and families.
Thank you all very much. Really appreciate you being here and it's helpful discussion. Thank you. Okay, I'm going to call our next panel of public witnesses, Joshua Miller, Taisha Andrews, joining us virtually, and Tayo Bell, also joining us virtually. All right. Joshua Miller, Research and Advocacy Director of Open City Advocates.
Good morning. I'm a resident of Ward 4 and Research and Advocacy Director of Open City Advocates, which provides legal representation and holistic advocacy to youth who have been committed to DYRS. I'm here today to testify regarding the first three provisions of the bill. At Open City Advocates, we support the rehabilitative purpose of the juvenile legal system. This often means that system actors need significant discretion to work with young people to identify responses that are individually tailored to their needs and responsive to the incentives that can alter their behavior. We would thus oppose any loss of discretion for young people charged by the Office of the Attorney General at this time. We believe that diversion, consent decrees, delayed disposition, adjudication, prosecution, etc., are all useful tools that should be available to prosecutors. Indeed, as we recently read in the DC Auditor's crossover youth audit with the Council of Court Excellence, DC needs to use more diversion to prevent crossover youth from finding themselves in secure placements in the delinquency system. There is a tension between two values here, and given the district's history and special status, this is especially important. Prosecutorial discretion is often cited as one of the causes of mass incarceration. In the 70s and 80s, prosecutors across the country went from charging roughly 1/3 of the arrests that were brought to them to 2/3 of these arrests, which is one of the main drivers for the United States having the highest incarceration rate in the country and in the world. Yet some people have also claimed that the recent crime wave in the district was partly caused by the U.S. Attorney's Office low charging rates for serious crimes, which they claim causes impunity. In this environment, the Office of the Attorney General has often been cited as a more responsible prosecutor. Thus, it is surprising that this bill seeks to remove discretion for various alternatives to legal proceedings and incarceration from the locally controlled Office of the Attorney General. The requirement that DYRS facilitate pre-adjudication family group conferences and design family rehabilitation plans worries us for a different reason. We've repeatedly shared with this council that DYRS is currently overcrowded and understaffed. We keep on hearing about care coordinators leaving the jobs. DYRS can't be asked to handle this task right now, while it is struggling to manage its core functions. At present, DYRS is unable to provide complete case planning to committed children under its care. Right now, they are not implementing the youth level of service inventory with fidelity, which is a key risk and needs assessment at the heart of its rehabilitative mission. Right now, we're still not providing robust services to committed young people in the community where they can be safest and closest to their families, with the lowest collateral consequences and the fewest compounding traumas. Right now, we still don't have community mental health providers in place for the upcoming Medicaid waiver to provide transitional support. DYRS isn't following its own policies on discharge planning, and they struggle to give kids meaningful team decision-making meetings every 90 days. We see instances where they don't even seem to know their own graduated sanctions policy, and programming is so limited that access to things that are meant to be privileges, like television and video games, are frequently just used to fill time. Those are some things that the Road Act could help to alleviate that this bill would not help solve. We just can't pile more responsibilities on this agency right now. If we are asking for DC agencies to take over pretrial and probation supervision from the federal court social services, then this should be spelled out clearly and resourced appropriately. The current agency that performs these tasks has a budget of nearly $26 million, funded by the federal government. I doubt we really want to shift these costs onto the local government during a tough budget year, even though the insidious force of this argument is that we continue to depend on unaccountable federal agencies to perform core tasks that we will eventually have to tackle if we ever hope for full home rule. Juvenile defenders often talk about in terms of deep end agencies and shallower ones, agencies that incarcerate, supervise, and coerce young people, versus those that teach, house, feed, and provide recreational opportunities and mentors. In this sense, DC's public schools are shallow-end institutions. Certainly, a combination of suspensions and mistreatments in a school setting can ultimately sweep a young person into the deep end, but most kids, most of the time, can experience school as a positive force in their lives. My concern with tasking DRS with pretrial activities is that this brings uncommitted children into contact with the deep end prematurely. Like many of its other outreach efforts, for instance, the OASIS program located near New Beginnings, which isn't accessible to committed youth, these are activities that are better handled by other agencies. Positive youth development techniques should be imbued throughout all of our youth-focused institutions, and while we want YDRs and corrections officers to act as mentors and caregivers, we don't want young people to only be able to find mentorship and caregiving in prisons. I'm happy to answer any questions. Thank you.
Thank you, Mr. Miller. Tayo Bell, Deputy Director, School Justice Project. Tayo Bell. We can't hear you if you're on.
Good morning. My name is Teo Bell, and I am the Deputy Director of School Justice Project, as well as a Ward 4 resident. SJP is a DC-based legal services and advocacy organization that uses special education law to ensure that older court-involved students with disabilities can access a quality education. Council has heard today from other witnesses about the detrimental impact on the policy side.
Tayo Bell.
Yes, I'm here. Are you able to hear me?
Hear you if you're on.
Okay.
Yes, we can hear you. I think that's coming from another source.
Okay. Are you able to hear me?
Yes, we can hear you.
Okay. Would it be okay if I restart my testimony?
Sure. We heard you up until just the last sentence.
Okay, great. So what I was saying is that the council has heard from some of my fellow witnesses today about the detrimental impact to the legal system and those involved in it if diversion programs and deferred prosecution agreements became highly restricted. Today, I'd just like to share a couple of SJP client examples where our clients were offered DDAs and the significant positive impacts those DDAs had on our clients. SJP represents a client who was charged with a simple assault and subsequently placed in a group home by the family court following his arrest. At his hearing, the judge recognized that the client appeared to be on a better path during his time at the group home. As a result, the client was offered a DDA in his delinquency matter. After pleading guilty, as required by all DDAs, the judge entered a 6-month DDA. As part of that agreement, the client also had to accept a number of terms as outlined by the DDA. One requirement the client accepted was regular attendance at Balance and Restorative Justice Drop-In Center, commonly known as BARGE. While at BARGE, our client typically used his time doing his schoolwork, but more importantly, he used his weekly time at BARGE to get to know his mentor. The mentor there at BARGE became a reliable adult in our client's life who worked with him and the other young people to address their feelings in a group setting, and as well the challenges that they faced that brought them into contact with the juvenile justice system in the first instance. In fact, in this client's experience, the client developed a healthy respect and appreciation, not only for the mentor, but also for the probation officers who were at BARGE. Another client example that I'd like to share involves one of SJP's clients who was arrested for a quote unquote dangerous crime, which under the mayor's proposed legislation would make him ineligible for a DDA. This was the client's first instance of court involvement. The client was mandated to take his schoolwork to BARGE, and like our other client, he made good use of the time he spent at BARGE by catching up with his schoolwork. This client was also assigned a probation officer who took a great interest in the client and ensured that if the client did not have a way to get to BARGE, he would pick up our client and take him to BARGE to remove the barrier that prevents a challenge for so many of our clients, which is reliable, safe transportation to and from BARGE. Not only did this client successfully complete his DDA, but all parties and the judge agreed to terminate the DDA a couple of months early, given the client's very successful completion of the terms. These two examples are two of many I could offer from SJP's client base, and they're indicative of why juvenile justice interventions must continue to be available as currently prescribed under law and not further restricted. The evidence is clear from our CJCC. DPAs, DDAs, and diversion programs work. Under the mayor's significant proposed limitations to these critical interventions, there are few instances in which SJP's clients would qualify for these critical interventions, which would be a great shame given the successful impact that they've had on our clients as demonstrated by the stories I've shared today. SJP thanks the council for holding this hearing today on Titles 1 through 3 of the mayor's proposed UPLIFT Amendment Act. And I am around, but unfortunately in travel, and available to answer any questions. Thank you.
Great. Thank you very much, Ms. Bell. Thank you for sharing those examples of effective diversion and outcomes. I'm curious if you can share, I don't know if you have any of this data on the aggregate, but how outcomes are looking for clients that you've worked with over the longer term. Is there follow-up that SJP is engaged with after 6 months or after a year, or even 2 years to see how the child is doing and if they need additional supports?
Unfortunately, at our small organization, we're still working through ways to measure and assess those types of metrics, which is a bit of an ongoing project for us. So no, directly to your question. I mean, I can say anecdotally that in those situations that I outlined, a few that were highlighted by my colleagues, those students are still doing well. Those are clients that we're still engaged with, who are still attending school, who are still, very much involved in, their school work and staying on the right path. But unfortunately, at this time, we do not have further data at a 6-month or 9-month interval, though we are literally working on it right now. So hopefully the next time we have this type of conversation, I'll be able to report back something different.
Okay, thank you. But just to make sure I understand, as a general matter, you do stay engaged with your clients?
Yes. Yes, absolutely. SJP remains engaged with our clients through graduation and the end of their court involvement. So for a client who has successfully completed a DDA, that may mark the end of their court involvement, but not the end of their education. In that case, we remain involved with the client through graduation and even into post-secondary planning. We have a number of clients that we're currently helping complete their FAFSA and trying to, help them enroll in college programming. Others of our clients, we remain involved with them pretty significantly throughout the course of their both, family court and also criminal division proceedings.
Thank you very much. And Mr. Miller, I'm curious about your testimony as it relates to CSSD and the kind of like short-term challenges and where that fits in our long-term mission for more autonomy. And so almost removing the conversation of these particular sections of this bill, where do you think some of the major gaps are along the continuum once a crime has happened? Again, to our earlier discussion, there are many gaps that we know about on the intervention side, the prevention side. But when you're dealing with clients when they're already committed, where are you seeing additional systems break down, whether that's prosecution, in deferred agreements available, whether that's rehabilitation going on or not going on at DYRS, CSSD follow-up? Where are some of those other gaps that we should be looking as we continue to strive to improvements?
It's a great question. I don't have any specific criticism to offer of CSSD. I think that is worth your committee's time to investigate the role that they play. And I think that they like other federal agencies often fail our specific needs. But once a child is committed, we see a variety of different places where things break down. And I was trying to sort of work through all those things in my testimony. So from the very beginning, we're not seeing case planning happening, right? We're not seeing discharge planning happening. So at the beginning, we sometimes say reentry starts on your first day of incarceration. You know, you would expect that an agency that is committed to rehabilitation would very quickly be assessing somebody's needs. What, you know, do they have any mental health needs? Is this a housing issue? Is this tied to interfamily dynamics? You know, what brought you here? What do you need to leave as quickly as possible? And how can we support you once you're in the community so that you don't reoffend? And so, you know, we're not seeing we're not seeing programming happening at YSC, at the Youth Services Center, the jail. We're not seeing people moving through the sort of levels of rehabilitative behavioral modification in a way that indicates that there's a strong plan and that, you know, there's regularity. You know, we often see people getting step backs for things that should probably have been a graduated sanction instead. And then we see discharge planning happening like the day of discharge, right? So, you know, you're going to let somebody back outside. You're sending them home to their family. You could have been and should have been planning that for months, right? And we just don't see that occurring. So that's I think the second half of your question. I do think there are other experts in the room who could speak specifically to CSSD, and would be better able to address the particular ways in which they're failing our children.
Thank you very much. Thank you, Mr. Miller. Thank you, Ms. Bell. I appreciate all of our public witnesses for being here today, and for the work that you do and for your perspective on these bills. We are now going to call our government witnesses to the table. We are going to just wait a minute while everybody gets in the room. All right. Okay. Yes, there are three of you. So we'll have, sure. Sure, no problem. This is our room. It's everybody's room. We have Deputy Mayor Apia here. Have Attorney General Schwab, welcome. Seminova from the Public Defender Service, welcome everybody. Thank you all for being here. All right. We have with us today Lindsay Apia, Deputy Mayor for Public Safety and Justice, Brian Schwab, the Attorney General for the District of Columbia, and Katerina Seminova, Special Counsel of the Public Defender Service. I see some folks have members of their team with them. If you are going to be participating, if you could state your name and position for the record. Make sure the microphone is on.
Lauren Haggerty, First Assistant Attorney General. Good morning.
Name?
Or good afternoon. Or no, good morning.
And good morning. My name is Hannah McElhenney. I'm head of the juvenile section at the Public Defender Service.
Great. All right, wonderful. Well, as you all know, it is the tradition of this committee to swear in all government witnesses who appear before it. So if I can ask you all to turn your microphone on and raise your right hand. Do you swear or affirm under penalty of law that the testimony you're about to provide before this committee is the truth, the whole truth, and nothing but the truth?
Yes.
Wonderful. Thank you so much. I'd now like to invite you, Deputy Mayor Apia, to make any opening statement that you may have.
Thank you so much. Good morning, Chairperson Pinto, members and staff of the Committee on the Judiciary and Public Safety. I'm Lindsay Apia, Deputy Mayor for Public Safety and Justice, and I'm testifying today on Bill 25-791, the Utilizing Partnerships and Local Interventions for Truancy and Safety, UPLIFT Amendment Act of 2024. Mayor Bowser introduced UPLIFT, which focuses on early intervention, alternative in-school placements, enhanced family engagement, and accountability to keep young people safe in school and engaged. Increasing public safety and reducing crime continues to be the executive's #1 priority. Over the course of the past year, We have focused on introducing and implementing policies, policing strategies, and strategic partnerships that are helping us to reduce crime and increase safety in all 8 wards. To date, we have a 24% decrease in homicide, 26% decrease in assault with a dangerous weapon, 29% decrease in robbery, 27% decrease in total violent crime, and a 15% decrease in total crime when compared to 2023. Additionally, we have a 10% decrease in violent crime and a 12% decrease in total crime when compared with 2019. We're encouraged by these reductions, but we know more must be done to continue to drive down crime in our city. This is particularly true in relation to juvenile crime. There are still far too many youth perpetrating and being victims of crime. For example, while we're seeing a 42% reduction in armed carjacking and a 34% decrease in carjacking offenses overall, there is a 68% increase in juvenile arrests for carjacking this year. There have been 30 juvenile gunshot wound victims with 7 fatally wounded, 1 more than at this time in 2023, despite the significant decreases in ADWs overall. Mayor Bowser has repeatedly said that we must rebalance our public safety and justice ecosystem and task the executive with making difficult but necessary adjustments to interventions that are not yielding the results that they must if we are continuing to make safety gains. Over time, a host of changes were made to our ecosystem and impacted by all stakeholders, which now must be reconsidered and readjusted to continue the progress in reducing crime and increasing safety for everyone in our city, including our young people. It's worth noting, as we have on several occasions, the unique complexities of the district's criminal justice system. These complexities are magnified in the juvenile justice system because of the inherent difference in young people and the role that the system plays in not only holding youth who commit crimes accountable, but also safeguarding and providing for their mental, emotional, and physical needs. In the district, young people charged as juveniles are prosecuted by the Office of the Attorney General, adjudicated by our federal DC Superior Court Family Court Division, and supervised by the executive through the Department of Youth Rehabilitation Services or the Federal Court Social Services Division of the DC Superior Court. Additionally, they can be diverted through a host of routes, which include the Superior Court's Juvenile Behavioral Diversion Program and Here Opportunities Prepare You for Excellence Court, Hope Court, OAG's Juvenile Deferred Prosecution Agreements and Deferred Disposition Agreements, and the Department of Human Services Alternatives to Court Experience Program. As part of our evaluation process, the executive examined changes to the juvenile justice ecosystem since 2012, resulting in the chart which I'm submitting for the record. Some key findings include juvenile carjacking arrests have quadrupled since 2020 and jumped 3,800% since 2012. Juvenile arrests for unauthorized use of vehicle, UUV, and stolen auto jumped 180% between 2013 and 2023. Despite these increases in arrests for violent crimes, the overall rate of cases filed in CSSD consistently went down, and DORS committed youth average daily population dropped 86% between 2012 and 2023. And the District of Columbia Public Schools truancy rate increased from 27% in school year 12-13 to 40% in school year 21-22, but decreased to 35% during last school year. Also, while overall juvenile arrests have declined over time, juvenile arrests for violent crimes continues to increase. Per data published by this Criminal Justice Coordinating Council, because of the Prioritizing Public Safety Emergency Amendment Act of 2023, we know that 635 juveniles were arrested for violent offenses in 2023. We have many more youth committing more serious offenses at younger and younger ages. There are many more metrics that could be added to this chart or that we could discuss. However, our proposals in UPLIFT address some of the most impactful and immediate issues driving juvenile crime and violence across the ecosystem. I'll now turn to the provisions before this committee and the subject of today's hearing. Title I, Parental Participation Orders. While we believe that it takes a village to raise a child and are committed to supporting families, we also firmly believe that the primary responsibility for children rests with their parents and guardians, and that when youth are engaged in crime, parents and guardians must be appropriately accountable for engaging in their child's rehabilitative process. Currently, Section 162325.01 of the District of Columbia Official Code requires the court to, quote, enter an order specifically requiring a parent or guardian to participate in the rehabilitation process of a juvenile, including but not limited to mandatory attendance at a juvenile proceeding, parenting class, counseling, treatment, or an education program. The penalty for failure to comply with this provision can be civil contempt, and the court can issue a bench warrant for any parent or guardian or person with whom the child resides. However, these orders are not uniformly entered, as you've heard, and they are rarely, if ever, enforced, even in those limited circumstances when they are entered. Parents are vital to their children's rehabilitation, and there is nothing that we have heard more loudly and consistently from communities across the city than the need for greater parental accountability. UPLIFT strengthens the parental participation provisions by requiring parents or guardians of youth on pretrial community release to participate in a mandatory family group conference with DYRS. The group conference will assess what is needed to assist the youth and family in moving towards a more productive path, and provides and requires them to engage in services identified in a subsequent family rehabilitation plan if their child is charged with a dangerous crime while armed with or having readily available a knife, pistol, firearm, or imitation firearm, or a crime of violence. Titles 2 and 3, limitations on pre and post adjudication diversion. All parts of the district's juvenile justice system, including the deep end of the system, are rehabilitative in nature. DC Code 162301 et sequential, which establishes our system, outlines several goals, including to promote youth development and prevent delinquency through early intervention, diversion, and community-based alternatives, to hold a child found to be delinquent accountable for his or her actions, taking into consideration the child's age, education, mental and physical condition, background, and other relevant factors, to place a premium on the rehabilitation of children with the goal of creating productive citizens, and to recognize that rehabilitation of children is inextricably connected to the well-being and strength of their families, to hold the government accountable for the provision of reasonable rehabilitative services, and to provide for the safety of the public. Title 2 and 3 of UPLIFT are aimed at readjusting and realigning our system to fulfill these statutory goals by ensuring the court has greater insight and oversight of youth charged with violent crimes or dangerous crimes while armed. Specifically, the proposed legislation would limit the eligibility for diversion for youth charged with a dangerous crime while armed, consent decrees for youth charged with a dangerous crime or crime of violence while armed, deferred prosecution agreements for youth charged with a dangerous crime while armed, and deferred disposition agreements for youth found guilty of committing a dangerous crime while armed or having available a knife, pistol, firearm, or imitation firearm, or a violent crime. While there's limited data about DPAs and DDAs, there have been substantial increases in their use by OAG over the past several years. Originally, these agreements were modeled on their use in the adult criminal justice system. However, there has been a significant divergence between the use of these agreements in the adult system, where they're primarily used for nonviolent and property offenses, and the juvenile system. Last calendar year, 418 unique youth had a CD, consent decree, DPA, deferred prosecution agreement, or DDA, deferred disposition agreement, and over half of the lead charging offenses were for violent offenses and dangerous crimes, 171 for violent offenses and 118 for dangerous crimes. This is in direct contravention to the council's findings indicated in DC Code 162305.01, which specifically limits juvenile diversion programs and services to nonviolent offenses. During a recent announcement, OAG stated, in the most serious criminal cases, young people who are arrested, prosecuted, and found responsible for offense are committed to DYRS. With nearly 300 youth with violent or dangerous offenses as their lead charge with a DDA, DPA, or consent decree, this is simply not the case. It is unclear what the parameters of supervision of a youth subject to these agreements consists of. And unlike DYRS, which is subject to the oversight by council and a host of other entities, there's no direct oversight such that we can ensure appropriate accountability for positive public safety outcomes arising out of use of these agreements. Additionally, it's unclear what assessment tools are utilized and which rehabilitative services are being provided to the youth pursuant to these agreements. In the Recidivism Reduction Oversight and Accountability for DYRS Road Act legislation recently introduced by the Attorney General, OAG advocates for greater standards and structure for juvenile justice involved youth, including the use of an objective and validated method to evaluate the static and dynamic risk factors relating to the youth and their environment that reduce likelihood that the youth will engage in future delinquent acts, criminogenic and non-criminogenic needs factors, and other factors that inform the specifics of a robust individualized treatment plan. The executive believes that all youth involved in violent conduct should benefit from these same standards of assessment and treatment. During a recent roundtable on violence interruption by this committee, the Attorney General expressed support for a merger of OAG's Cure the Streets Violence Interruption Program with ONE's Violence Intervention Initiative, noting that it's difficult to access the necessary services for long-term rehabilitation for the at-risk population served by Cure as an independent entity because services vest primarily within the executive. We agree and are concerned that youth who have committed the most serious violent offenses cannot be provided with the appropriate interventions for the same reason. The mayor has stated that we want all young people who commit crimes under our supervision, and that's a complex undertaking. But as we said, when Mayor Bowser introduced the Addressing Crime Trends Act Now, Amendment Act, we can't fail to act now on our current reality. It's our firm belief that more oversight by the court of those youth charged with the most serious offenses is a vital step in ensuring more accountability for youth and better outcomes for youth and the public. While there's little information currently available for the public on the substance of OAG's DDAs and DPAs, the interventions provided, and the long-term outcomes for the youth subject to these, we're hopeful that the Secure DC data sharing provisions has and will shine a light about what is happening across our public safety and justice ecosystem. This provision will better help us understand which programs are working and which aren't, so that we can continue to rebalance in our system in a way that helps our young people and keeps our community safe. The question I asked during last year's hearing on Safer, Stronger Amendment Act remains at the forefront of every decision impacting our youth. What does love look like in public policy when it comes to protecting children? As adults, we have a responsibility to keep young people safe and also to keep community safe. Creating necessary boundaries informed by the principles of positive youth development is loving. During the legislative process for the Safer, Stronger Amendment Act, Addressing Crime Trends Now Act, and Secure DC, we listened and asked everyone in all 8 wards to be introspective about how we can work together and what must change. People offered a host of ideas of how they can contribute to the safety of our city, but they also have been clear that accountability for everyone, including those who do harm by committing crime, must be prioritized. As the mayor said in April when introducing UPLIFT, we must work together as a community to put meaningful interventions in place that better support young people and their families. Our position remains the same as it's always been throughout the mayor's tenure. We are a second chance city that firmly believes in justice and equality for all, including respect for the constitutional rights of those accused of crime, that no person is the sum total of their worst decision, that positive life change is possible, and we're here to provide support and opportunities to those who wish to take a different path. That restorative justice is the correct model and accountability is a critical part of restoration. We also believe as leaders, we have a duty and responsibility to do everything in our power to protect community from those who choose to engage in violent offenses. We remain committed to making our city one in which residents and visitors across all 8 wards can flourish and thrive, and will continue to remain focused on rebalancing our public safety and justice ecosystem to reduce crime and increase safety for all our residents and visitors. Thank you for the time. I'll answer any questions you may have.
Thank you very much, Deputy Mayor. Attorney General Schwab.
Happy to allow PDS to go first unless you'd like me to go first.
Sure, not a problem. Katarina Seminova from
Thank
Public
you.
Defender Service.
Good morning. I'm Katerina Seminova, Special Counsel for Policy and Legislation at the Public Defender Service for the District of Columbia. With me today to help answer questions is Hannah McElhenney, Deputy Trial Chief in charge of PDS's Juvenile Division. Ms. McElhenney has spent more than 2 decades representing youth and supervising their representation in juvenile court. Thank you for this opportunity to testify on the first 3 titles of the UPLIFT Act. Despite the acronym, the first 3 titles of the so-called UPLIFT Act will fail to uplift any youth or family, and they should be rejected by this council. Specifically, PDS strongly opposes Titles 2 and 3 of the UPLIFT Act, which run counter to the rehabilitative purpose of juvenile court. Those titles supplant careful, individualized assessments about the rehabilitative needs of youth and the safety of the community with blanket legislative action that is based on 0 information about the youths, their families, their strengths or challenges, or the particular facts of their cases and the public safety issues at stake. PDS views Title I of the UPLIFT Act as superfluous, given the broad authority that family court judges already have to order parental participation for system-involved youth. By focusing on parental participation and assigning yet another role to the Department of Youth Rehabilitation Services, Title I misses the real issue, which is that DYRS is failing to evaluate committed youth and then either provide them with appropriate community-based services or move them to rehabilitative placements. With respect to Titles II and III, the amendments proposed in these titles run counter to the nuanced and thoughtful principles presented in DC Code 162302 as the goals of the juvenile legal system. These goals include promoting youth development and preventing delinquency through intervention, diversion, and community-based alternatives, placing a premium on the rehabilitation of youth, holding a child found to be delinquent accountable for his or her actions, taking into consideration the child's age, education, mental and physical condition, background, and all other relevant factors. Instead of focusing on rehabilitation and the promotion of youth development, the proposed amendments limit the discretion of system actors to tailor appropriate interventions for children. The proposed amendments would require the Office of the Attorney General, the court, and court social services to treat all children who are charged with certain offenses in the same manner, regardless of their age, family circumstances, whether they have been victims of abuse or sex trafficking, and regardless of their role in the offense. The amendments would prohibit OAG from placing a child in a diversion program, even if the best way of promoting the rehabilitation of that child was their immediate placement into that program. Further, forcing the full prosecution of a child who would be compliant with the conditions of a diversion program reroutes necessarily limited prosecution and court resources away from other children who may require more oversight and intervention. In this way, the proposed amendments remove the individualized decision-making that is at the core of the juvenile system and unnecessarily burden judges and the court system. The proposed amendments also stem from a basic misunderstanding of the juvenile legal system. Deferred prosecution agreements, DPAs, consent decrees, and deferred disposition agreements, DDAs, do not prevent a child from being held accountable. In many instances, children must accept responsibility and plead guilty as part of these agreements. Diverting a child out of the regular court process typically places the child under immediate supervision with the same range of system interventions tailored to address the child's needs and strengths as can be used for children who have been found involved after trial. Children with consent decrees, DPAs, and DDAs have been ordered to participate in mental health treatment, mentoring, family counseling, and vocational and educational programming. They have received services that have helped them obtain summer employment or participate in sports, all activities that help them reconnect in the community in positive ways. Children under these programs may also be ordered to comply with strict curfews and stay-away conditions and can be placed on 24-hour GPS monitoring. Deferred prosecution agreements, deferred sentencing agreements, and consent decrees are also a powerful motivating factor that drive participation in treatment courts, such as Hope Court and the Juvenile Behavioral Diversion Program. Participation in these courts is vital to getting children the specialized services that they need to address victimization through sex trafficking and persistent mental health challenges. These specialized courts come with services that are not otherwise readily available, such as gun violence prevention programming, cognitive behavioral therapy, and restorative justice groups, as well as programs designed for children who have experienced commercial sexual exploitation. Children in these programs come to court more frequently and have a greater connection with case managers and counselors. The success of these specialized courts is fueled by OAG having the discretion to divert children from traditional court to programs that will foster rehabilitation and recovery from profound trauma and mental illness. Many children have succeeded as a result of their participation in these specialized courts and as a result of being afforded the opportunity to have their juvenile system involvement end in a non-conviction. Youth understand the benefit of working toward a clear record and are motivated to comply with their conditions of supervision. Children who have been afforded the opportunity to earn diversion face fewer collateral consequences as a result of their system involvement. They can say on college applications and student loan applications that they do not have a conviction. Juvenile adjudications are not used against them in applications for the military or for the MPD cadet program. Numerous system-involved youth have sought PDS's services for sealing juvenile records, but that relief is not enough. The best way of preventing collateral consequences and putting young people on a path to success is by allowing them to earn the right to a non-conviction. Preserving the discretion to grant these alternative dispositions is the best way of preserving hope and the possibility of positive outcomes for youth. It should also be clear to the council that in addition to incentivizing success, these programs disincentivize and punish failure, giving youth every reason to comply with the strict conditions of their agreement. In the case of a deferred disposition agreement, children plead guilty and agree to a period of supervision and conditions that can extend for a lengthy period of time. If a child fails to comply with their DDA, intervention is much faster than in the probation revocation process. The OAG has unilateral control over the question of compliance and can revoke the DDA. The child then proceeds to disposition, the juvenile equivalent of sentencing. At that point, the judge has all the dispositional alternatives available, including commitment of the child to DYRS until age 21 or imposing a term of probation, prolonging system involvement and creating more time on supervision. If the youth does not comply with probation, probation can then be revoked and the youth again faces commitment to age 21 at a new disposition hearing. Nothing about a DDA is an easy path for youth. Similarly, consent decrees and DPAs also hold youth accountable. If a child fails to successfully complete their period of supervision under a consent decree, they restart the juvenile court process. They must enter a plea or face trial and disposition. At disposition, they again face the possibility of commitment until age 21 or a period of probation that can be revoked for noncompliance. PDS frequently advocates for clients to receive these alternative dispositions and for them to have the opportunity to earn a non-conviction. These alternative dispositions are not awarded liberally. In countless instances, PDS clients have been denied these opportunities. When OAG chooses to use its discretion to give children DPAs, DDAs, or consent decrees, they serve as one of the best tools the district has to incentivize success, provide individualized services to youth, and place children on an entirely different path. The prosecutorial discretion to radically alter the lives of youth for the better should be preserved. With respect to Title I, this title requires parents to participate in a family group conference if their child is charged with a crime of violence or dangerous crime while armed and is not held pretrial at a DYRS facility. Family group conference is not a term that is defined in the DC Code, and it is not something that DYRS performs for children who are released pretrial. Currently, DYRS has no involvement with children who are released pretrial. Children who are released pretrial are supervised by Court Social Services. Court Social Services does convene a family group conference, and judges can already order parents to participate in those conferences. In fact, under DC Code 162301, judges must order parents to participate in their children's juvenile cases, and parental participation orders are entered in every case. The problem with Title I is not only that the law already allows judges to order parental participation in essentially any case-related matter, but that it orders DYRS to perform new functions that are not part of its mission for youth who are not in the agency's care. DYRS already struggles and fails to provide timely assessments for youth who are in its physical custody. Over the last 2 years, the waiting placement population at YSC has ballooned, a problem caused largely by DYRS's failure to evaluate committed youth and move them to appropriate long-term placements. Children in DYRS facilities are not getting the evaluations or attention that they need from the limited case management staff who are available. DYRS is also severely understaffed and lacks a sufficient number of youth development representatives who serve as day-to-day staff at DYRS facilities, secure facilities. At a council roundtable that addressed safety concerns at the Youth Services Center, DYRS's director spoke about the possibility of having other staff work overtime as YDRs. The lack of case management staff, the lack of facility staff have cascading effects, depriving youth of effective case management and leading to an overcrowding of the secure facilities. The overcrowding then leads to a denial of services in an unsafe environment where staff routinely used lockdowns to manage high population numbers. Given DYRS's inability to handle its obligations to the children who are at the core of its mission, adding to DYRS's case management workload makes little sense and is in fact counterproductive. Children who are on pretrial release need community-based services. The essential missing piece for these youth and their parents is not an assessment by DYRS or a mandate for parents to participate in a new meeting convened by DYRS. The missing piece is access to core service agencies and community-based mental health care that will provide children with the services that they need. Parents and children are spending their time searching for providers and on waiting lists for intake and then on waiting lists for appointments, a problem that DYRS has failed to manage for committed youth who are at home. If the aim of Title I is to enhance accountability by mandating parental presence in juvenile court-related proceedings, nothing that is proposed will have a positive impact in that direction, and the proposal will instead take needed resources from committed youth. Thank you for the opportunity to testify, and I welcome any questions.
Thank you, Ms. Seminova. Brian Schwab, Attorney General for the District of Columbia.
Good morning, Chairwoman Pinto. Council members, I appreciate the opportunity to testify this morning about the mayor's proposed legislation. I thank Chairman Mendelson for bifurcating consideration of this bill between Titles 1 through 3, which are the subject of today's hearing, and the remaining titles regarding truancy and school discipline. I will have much more to say on the latter topics at the Committee of the Whole's future hearing. But I appear today before you to express strong opposition to Titles 2 and 3, which offer ill-conceived proposals that are divorced from the data, reflect an emphasis on politics over problem solving, and would violate the district charter by infringing upon the independence and exclusive prosecutorial discretion of the Office of Attorney General. I'll hold my concerns about Title I, which I also oppose, for further discussion after opening statement. At their core, Titles 2 and 3 of the mayor's proposed legislation seek to force my office to funnel more youth into commitment with the Department of Youth Rehabilitation Services, which we know is struggling currently to handle the youth already in its care. These proposals appear to be premised on the flimsy and misplaced assumption that last year's spike in youth crime was attributable to a lack of prosecution from my office. That assumption is inconsistent with facts on the ground, inconsistent with data, and inconsistent with the real world we're living in. My office prioritizes accountability and rehabilitation for youth, both of which are statutorily mandated under the Juvenile Criminal Code. That balance is key to reducing recidivism, preventing crime, and thus to promoting public safety in our city. In every case that comes to us, there are several possibilities for disposition, ranging from dismissal to long-term commitment with DYRS. Allow me to walk through some of the outcomes for a young person who is arrested for a crime in the district. MPD has three main options at its disposal when it arrests a young person. Release the youth if MPD lacks probable cause that the young person committed a crime. Divert the youth to the Department of Human Services Alternative to the Court Experience ACE program without ever sending the case to my office, or referring the case to my office after making an arrest. Once a case comes to the Office of Attorney General, we have several options available. If we do not believe we have enough evidence to prove the case beyond a reasonable doubt, a standard which is noticeably higher than the proof MPD is required to have before making an arrest, we appropriately dismiss the case. If we believe there is sufficient evidence to prosecute, we can, just as MPD, divert to ACE. Of note, last year, most referrals to ACE for juvenile delinquency cases came from MPD, not OAG. In 2023, my office referred 138 young people to ACE for delinquency, while MPD referred 156. Notably, only 6% of the referrals from both agencies, MPD and OAG, 19 total young people, involved dangerous crimes or crimes of violence. I know you know this, and for our record, diversion to ACE is different than the alternatives to commitment that DDAs, DPAs, and consent decrees talk about. And we do a disservice to the conversation when we conflate diversion with the other types of tools that are available. Our office, in the exercise of its prosecutorial discretion, can also enter into court-approved consent decrees for the young person. Consent decrees, which are monitored by court social services, do not require an admission of guilt. They operate to suspend prosecution, usually for a period of 6 months, if the young person does not reoffend. If they fail to adhere to the agreement, they can be prosecuted for the underlying crime. We might use the consent decrees for youth who would otherwise be eligible for ACE, but who were not eligible during the intake due to the absence of a parent or some other technical procedural issue. In 2023, we did not enter into a consent decree for any case with a dangerous crime or a crime of violence. We can also enter into deferred prosecution agreements, or DPAs, which are similar to consent decrees and are supervised by CSS. DPAs result in the charges being dropped if the youth complies with certain conditions, and the DPAs can be revoked if the youth fails to comply. In 2023, OAG offered DPAs to less than 4% of the 1,168 cases that we papered, fewer than 10 of which involved commission of a dangerous crime or a crime of violence while armed. Let me pause before talking about deferred disposition agreements, or DDAs, which I think are the principal focus of this proposed legislation. So far, we have delinquency diversions to ACE, the majority of which come from MPD, and only 19 of which were for violent or dangerous crimes. We have consent decrees, none of which were used in the cases the mayor's proposal is aimed at. And we have DPAs, which were used in fewer than 10 cases of the sort the mayor's bill is focused on. All of these are pre-adjudication. In other words, in all of those cases, there has been no admission of guilt or finding of a court that the youth committed the crime, and the youth are still being given services and being held accountable by DHS or court social services. That brings us to DDAs, which do require a young person to take affirmative responsibility for their actions by pleading guilty. In a DDA, once a young person has admitted guilt and accepted responsibility, the court will delay disposition or sentencing and place the young person on what is effectively probation. If they comply with all the terms of the DDA, they will not be adjudicated or committed to DYRS custody. However, if they fail to comply with the DDA's requirements, including by reoffending, our office can ask the court to proceed to a disposition hearing, which may result in DYRS commitment until the age of 21. Youth have already admitted guilt and accepted responsibility, so there's no need for a trial. Last year, we used DDAs in only 89 cases involving a dangerous crime or a crime of violence while armed. That's less than 8% of all the cases that are papered by our office. As I've just laid out, OAG and the line attorneys in our office use diversion, consent decrees, DPAs, and DDAs sparingly. And in every instance, those agreements expressly require that the young person not reoffend during the period of supervision. If they reoffend, we retain the jurisdiction to reinstate their underlying case and can and do prosecute them to the full extent of the law. For DDAs, because the young person has pleaded guilty to the underlying offense, we are able to revoke the agreement and proceed immediately to sentencing, which frequently involves a commitment to DYRS. While we do not yet have complete data for the success rate of these alternatives in calendar year 2023, the data from the past 5 years shows that these discretionary tools are incredibly effective. Our successful completion rates, defined as youth completing their probation or supervision period in accordance with all requirements, are high. From 2019 through January of this year, the successful completion rates were 92% for consent decrees, 73% for DPAs, and 86.5% for DDAs. According to the Criminal Justice Coordinating Council, of youth in ACE in 2023, only 9.7% of them were rearrested for a new offense during the program, suggesting high successful completion rates. This data is backed up by an August 22 Criminal Justice Coordinating Council study on juvenile justice outcomes, which showed diversion, consent decrees, DPAs, and DDAs having lower recidivism rates than commitment to DYRS. The evidence is clear. The CJCC, which the mayor chairs, has found that these alternatives to disposition, when used appropriately, are successful at reducing recidivism. Our office uses these tools sparingly and only after considering the facts of each individual case to identify those with the greatest chance of success. And the vast majority of kids with these agreements successfully complete them without reoffending. In short, individualized interventions crafted by OAG prosecutors work effectively to keep the district safe. There's simply no factual basis for any assertion that the use of these interventions was a contributing factor to last year's spike in crime. Instead, the mayor's proposal reflects a talking points approach to crime, one rooted in rhetoric, not rooted in data and facts. The focus on alternatives to commitment is perplexingly misplaced, even more so considering that one likely outcome of the mayor's bill would be that more young people would be funneled into DYRS, an agency that is already struggling to meet its stated mission to rehabilitate kids. The most recent comprehensive study from the CJCC shows that 92.7% of kids committed to DYRS were rearrested during or within 2 years of commitment for either a new crime or a violation of their release conditions. And nearly 50% were adjudicated to have committed a new crime. The challenges DYRS is confronting are widely known, have been recently reported, and have been the focus of hearings before the council, including an emergency roundtable last week, as well as this council's establishment of a permanent independent oversight body. Now, I want to be clear, I'm not making an apples to apples comparison between OAG and DYRS data. DYRS is charged with rehabilitating kids who have committed the most serious violent offenses. That is a weighty and profoundly important obligation. But that reality makes it even more essential that we ensure DYRS uses its limited staff and its limited resources effectively. We don't do anyone any favors by funneling more and more cases to DYRS if we can successfully prevent recidivism with pre-commitment tools like diversion, DPAs, and DDAs. Prudent use of those tools will make the district safer by putting kids back on the right track, keeping them from committing more crimes, and allowing DYRS to focus on the youth who require the most attention. Aside from the lack of any factual basis for the mayor's bill, I want to express my concern about the legality of the mayor's proposal. The district charter, like the federal constitution, separates power among the 3 branches of government. Per decades of legal precedent, the intent of the mayor's proposal violates the charter's separation of powers. By design, the bill impermissibly seeks to intrude into the discretion of a prosecutor and the discretion that a prosecutor has to determine when to bring charges, by forbidding diversion in certain cases, and when to dismiss charges once filed, by forbidding consent decrees, DPAs, and DDAs. The proposal also impermissibly seeks to intrude on the specific authority to prosecute juvenile cases that the charter now gives to an independently elected attorney general. By voting to establish an independent attorney general that is no longer subordinate to the mayor, district residents have entrusted my office to use that prosecutorial discretion that the charter gives us and to use it wisely. The data shows that we are doing so. My office will continue to look closely at every case based on the unique facts and circumstances of every case. And we will prosecute every violent and dangerous case where we have sufficient evidence to establish guilt beyond a reasonable doubt. If there is meaningful data showing that alternatives to commitment are not working in the discrete, individualized circumstances where we use them, we are ready to engage in a conversation to explore other solutions. But these alternatives are working. The mayor's proposals are rooted in politics, not problem solving, and we cannot allow politics to trump public safety. In closing, I want to reemphasize the importance of legislating evidence-based criminal justice policies. In this instance, the evidence shows that discretionary alternatives to commitment, when deployed prudently, are effective for certain youth populations. The evidence also shows that DYRS needs more resources to handle the kids they already have in their care, not more kids to care for. I encourage this committee and the council to reject the provisions in Titles 2 and 3, and instead to take up the ROAD Act, which I introduced last week. That legislation focuses on helping DYRS get youth who are committed into its care back on the right path. Thank you.
Well, thank you, Attorney General Schwab, and thank you all for your testimony and for being here today. I'm hopeful that all of us here in the same space, at the same time, we can engage in a productive discussion about some of the differences of opinions with this bill and with our juvenile justice system. I want to start with you, Deputy Mayor, and kind of zooming out a little bit with our ecosystem. One of the things that really stood out to me earlier was a comment that was made by one of our public witnesses, Eduardo Ferrer, and I've heard this from kids too. And he said something to the effect of, if a child has a choice between getting shot or getting arrested, they're going to choose getting arrested. And so from your perspective, before there is ever a crime committed, what is your role? What are you doing to make sure that kids are protected in the first instance so that they don't ever feel that they need to arm themselves?
Sure. So, I mean, prevention is key, right? Like, and with young people, it's complex because when we talk about, you could kind of do primary, upstream, and all of these, right? Like making sure there are safe families, identifying young people when they're in the 3rd grade or 8 years old, if they're on a path that could lead to criminality down the path, and ensuring that there are pro-social supports for families and otherwise. That's all part of our role, right? Like that's somewhat part of my role. I mean, I think as Deputy Mayor of Public Safety, I'm further downstream, but we have a lot of discussions with the human service agencies, particularly CFSA and DHS, with the education agencies, where we literally sit around a table and identify young people who we know are at risk. That's a huge population. One of the ways that we identify is through basically taking young people who are on the missing persons list multiple times and doing some collective case planning around what is happening. That's honestly a very large and broad number. And so we zoom in a little bit more. We started a juvenile critical incident protocol several years ago, where young people who are shot or involved in what we considered a juvenile critical incident, a shooting, an incident around a school, any sort of a major assault, that there is then a sort of a joint process of determining who is that young person, who knows them. And this is with DHS, CFSA, MPD, the charter schools aren't on there, but the Deputy Mayor for Education, the Chancellor, trying to think of DYRS, any information that we have about that young person and their family, because our first sort of kind of triaging is, do we have any risk of any potential retaliatory violence? That's the first thing, right? And so then that goes to the VIs, credible messengers. There's a whole written protocol. We've talked about this multiple times. The next question we ask is, what's happening with that young person? And that's where really why schools, CFSA, and DHS are involved, because there are very, very few young people that aren't known somewhere in our system. One of the things that we are really trying to work out is who's on first, because what we've seen through this process is we almost always know a young person downstream once they're shot. We look back and there's been contacts that are kind of separate, right? Like DHS plays a specific role with a family. Oftentimes family may be in housing supports or otherwise, but there's an issue. CFSA has a very specific touch point. DBH has a specific touch point. And so I think the challenge that we have in our prevention space that we're really working through, and that we've done on the adult side, right? Like, just, I say this because we were in here not long ago, there's a 41% reduction right now in one's priority areas of ADWs and homicides, right? And it is a lot of based on what we talked about. You have to take each individual, however you're identifying them, and figure out what the needs are. We're working on that on the juvenile side, with the mayor really involved, and has been for a couple of years, of really bringing us to the table to figure out how we narrow in on the most at risk, because it's broad. It is very broad.
Yeah.
Yeah.
And I appreciate that, and those examples. I guess I'm thinking even more zoomed back.
Okay.
Like, I'm a young person. I am scared to get to school.
Sure.
And the only thing I can think of is to arm myself so that I'm not shot first. Like,
Yeah.
what are we doing to address that problem? Because I hear it
Yeah.
all the time, and it makes it seem like, I mean, people are talking as though they're in war.
Yeah. So
And that's the verbiage they're using.
sure. And so there's multiple things, right? Like safe passages, right? Is one of the things for those reasons, because we want kids to feel safe getting to school and don't feel like they have to be armed. But it also is an identification tool to be like, what's happening in school? There is a challenge, and I will tell you sitting here, that some of the proposals you're seeing in the other parts of this or the statute is because there's a communication challenge, where some of the reasons young people might be afraid is something happening in school. There's an incident of bullying or some sort of fighting going on, and there's an information gap. It's easier to bridge with DCPS schools, but we have one of the broadest charter school. We have the broadest in the country, which means we have a lot of LEAs, some who feel comfortable sharing information with certain agencies and some who don't. Some feel comfortable speaking with CFSA to say there's a problem, but some see them as neglect focused and breaking up families. Some feel comfortable speaking with MPD, some won't, literally won't. So we have built sort of into the safe passage communication model some channels by which people can give information about what's happening in schools, because part of our prevention role is Why are they carrying a gun? Because there's often some source of what's going on. And then what are the interventions we can use to try and mitigate that? Whether it is, a lot of times it's an intervention by a safe adult, right? Like whether it's credible messenger, OLA, DPR, or we're building out lots more with coaches, somebody to identify what's happening so we can intervene.
Thank you. So as the executive has introduced this bill,
Sure.
what problems are you seeking to address with these types of interventions?
Yeah.
And what concrete steps do you think these steps will help take in getting us to what you're trying to do?
Sure. So I think the thing is, there's all this talk about politics. We don't have time for that. Like we had that same conversation last year, finger pointing politics. No, what we recognized was that the policies and practices on our side and the executive as well, that over a decade of time, if you look at it, there were choices made that got us to last year, but that there were signs along the way. Last year, when we're talking about a juvenile spike, last year, yes, there was an increase in juvenile, but if you look at it, it's been over time with juveniles, that the increases in violent crime arrests are going up, right? Even as overall arrests for juveniles are going down. So it's not about last year. It's about looking at, which we put on the record, the ecosystem over time. There's disciplinary changes, there's practice changes, there's a pandemic that interrupted social emotional learning, there's more availability of weapons, right? Like there's more movement of young people out of neighborhood schools into other neighborhoods that have a whole host of potential conflicts. All of those are things that we are examining and trying to make adjustments. People can, say that like policy doesn't, I've heard this doesn't change things, but in fact, if you look at the policies we put in place last year, we have a 27% reduction in violent crime. Like, and we could draw a whole host of reasons for that. So we recognize that in the juvenile space, we're not seeing that same reduction. Well, why? We have to look at what impacts young people. So that's why we have been talking about chronic absenteeism and recognize that's a huge warning sign for us of juvenile justice system involvement. And we have to get at why kids aren't coming to school. There's a host of reasons, right? Some of them just don't have clean clothes. And that it's literally like that kind of teaming that we're looking at, and we're addressing that from a practical. But here we're looking at a couple of things. Number one, when it comes to parental participation orders, parents must be involved. And there is a host of reasons they're not involved. Some are very overwhelmed. Some are at the end of their rope. Some of them have multiple children. Some of them can't be. All of that is a fact. But that doesn't they can't tap out. I'm just going to say it because our community's been clear that your child, your 13 or 14-year-old committing a crime isn't just a lone actor, even though in some respects, the juvenile justice system, that's the person, right, who's committed the offense. But there's no rehabilitation of anybody. A young person is a part of a family, whether a biological family, others, and a community. So we have to find a way to really strengthen those mechanisms. One of the things that I heard the Attorney General say when there was a discussion of parental participation orders at a public safety meeting, I think it was in Ward 4, he said, we're not going to criminalize parents. No one's looking for that. What we're saying is they have to participate, and we have to use some tools to get them there so we can support them. The reason we inserted DWRS is twofold. Number one, this whole thing about DWRS being, there's a lot of things that are being thrown around. The 2022.
For the Title I section.
Yeah, like, so about 2022 and all of those things. We could look at rearrests for last year. DWRS committed youth, 21%. CSSD had a 45% rearrest rate last year. Yet we're more comfortable with their supervision. You all don't have any authority over them. Can't supervise, don't know what they're doing, can't say if it's going well. We all have to be accountable. So for us, there's a twofold reason that we inserted DWRS there. One, if a young person's going to be committed, they go through a pre-commitment process where they will be assessed in some form or fashion anyways, because a recommendation has to be made to the court. If you commit, and this will happen, right? So they have a tool, the YLS, that they use for that, a validated tool. I am not going to shred CSSD, but I don't know what their tools are that they're using. And the other thing is, we're making a lot of decisions about where a young person should be in the system. What is that based on? So for us, best practice across the country is early assessment. So at the point, we're talking about a limited cohort of young people who've committed what we would say are the most serious offenses, violent or dangerous crimes with weapons, that we assess them to say this is the family need, that if CSSD is going to be the supervisor, that's fine, but somewhere the executive and quite frankly, counsel, who has a lot of supervision over the the executive agencies to do oversight, we have to be able to start to get our hands around what does this family need? And maybe we can provide those resources even though they're not under our authority, right? Maybe there's something we can do to help that family. Because if a young person is released while they have a carjacking charge or another armed charge, first of all, the courts are taking longer to hear cases because we know the courts are overloaded. That means they're in community for lengthy periods of time. What services are they getting? How are we saying that there's rehabilitation going on for a young person who's committed an armed offense when we don't know what CSSD does? We don't know what they provide. So that's part of it. That's really what all of this is to say we need to know more because what we're doing isn't working. And we can throw around data that's, I have the data from the CJCC. It doesn't match what the Attorney General's office is saying, but we don't know. But what we do know is that we're having more and more young people involved in carjacking. And right now, community, that was part of what was driving fear is the erratic nature of our young people's involvement in crime. And in a 6-week period last year, we had 5 kids that were under CSSD supervision with GPS units on their ankle shot or killed in 6 weeks. That's not working. So we can talk about politics and all these things, but we need to know more of what's happening with those young people. And if we're just saying that CSSD gets to make all the decisions or otherwise, you all don't have any oversight. No one does. We're
Right.
relying on Congress to tell us if our kids are actually getting what they need.
Yeah. So, and I just want to ask you, then I'm going to turn to some of our other, what it says. You mentioned in your testimony that you and the mayor believe in restorative justice.
We do.
And that, you know, restoration and rehabilitation includes accountability. Do you think that DYRS is doing a sufficient job at rehabilitation and restoration?
I don't know. I would never say that there's any agency that's doing a sufficient job, right? Because we did have 21% of the committee kids rearrested last year. But I would say this, DYRS has 166 kids. There were 635 kids arrested for violent crime last year and 400, I think I have the number, 443 that had a DDA or a DPA. So you're talking about a slice. Yes, they need to focus. What we're saying is those are the kids with the most, the highest acuity of honestly risk and need, right?
How is there, sorry, I just want to get to the bottom of this. How is there such a discrepancy in the numbers
This
of
is
the 10 and the 12?
So this is from where I'm getting my data from is this is the JSAT dashboards that are published by CJCC pursuant to the legislation. So I can only, that's all we have, right? Like I don't have other people's data. I can validate what MPD has given to them. I can validate what DYRS. These dashboards from, here it is, January 1, 2023 to December. Here's violent offenses, lead charge category for DDAs, DPAs, and consent decrees. 171 here says violent offenses. Dangerous says 118. That's what I'm going on. That's what
Okay.
we're baking.
So, thank you. So Attorney General, where are your numbers from, the ones that you cited in your testimony that are different than what the dashboard has?
I'm going to let First Assistant Attorney General Lauren Haggerty take that.
Sure.
Yes, Your Honor. Your Honor, I always do that. Sorry, Chairwoman. I'm a prosecutor at heart, so I can't get rid of it. So what I think the difference is, so for the CJCC dashboard that's looking at the distinctive youth who are on a consent decree, DPA or DDA, that may include youth who entered into one of those alternative disposition agreements in like 2022, because those agreements can range anywhere from 6 months to 9 months. What the Attorney General was citing are the actual youths who entered into those agreements in calendar year 23 and what the breakdown was for crimes of violence and dangerous crimes while armed. So that's where that discrepancy in numbers, but I'm more than happy to talk to your staff online to drill that down a bit more too. But that's at a high level.
Thank you. No, that's helpful. Okay, so I want to talk a little bit about prosecutorial discretion. And as we think about titles 2 and 3 and what I imagine is the executive's intention to make sure that those crimes that are most violent are being treated most seriously.
Yeah, and can I just say, it's not commitment. What we said is what we said last year, to go under the discretion of the court, because currently, yes, OAG is prosecuting, but DDA, or particularly, right, deferred disposition, by definition, which is again in the dashboard, are entered into and decided by OAG and respondent, right? So the court has no that's, I guess, maybe somewhere they oversee them. I don't know. That's really the part of what we're saying is that just like if a young person's entered into commitment now with their proposal every 4 months, but currently every 6 months, if the youth rehabilitative needs aren't being met, the court can review that. What we're saying is on sentencing, that for these youth with the most serious offenses, that there has to be more eyes. I'm not questioning whether the prosecutors, I'm not questioning anyone's whatever, but what I am saying is that there's a host of materials that go into the court's decision about what an appropriate disposition is. And that perhaps for those youth with the most serious offenses, that we need actually for the court to be making a determination.
So Attorney General, what are some of the factors that you are considering when you are contemplating the next step in a case for these violent cases?
So for every case we have, but particularly for the violent cases or the dangerous cases, they're all reviewed on the individual facts and circumstances of the case. Each case is different. From a prosecutor's standpoint, we're looking at the strength of the evidence. We're looking at how we're going to make the case if we have to prosecute it and move forward. We're looking at the seriousness of the offense. Like Mr. Ferrer talked about earlier in his public testimony, violent offense might be assault with a snowball, assault with a pear, assault with a shod foot. That ticks the box as a certain category, but it's obviously different than a case where you've got a gun being used. And so we look to the facts and circumstances that are involved. We look at the social factors of the young people involved. We look to how often, if at all, that young person has been involved in the juvenile justice system. We also listen to victims. We talk to the people who are affected by crime. And oftentimes, their wishes are ones that help us inform what the right plan should be. So there is not a one-size-fits-all to how we are exercising our discretion. But I do want to reiterate that these types of agreements, the DDAs, are sparingly used. And if you look at the overall body of work that we're doing, you're talking about a relatively small percentage of cases. These are the cases where it's a violent crime, where there's a weapon involved, which is the focus of the mayor's proposal. 89 cases last year out of a body of more than close to 1,200 that come in to our office. And the success rate that we track is that these young people in these situations are doing well for all the reasons that PDS has talked about, that Mr. Ferrer talked about, that the other public witnesses talked about, and that we're happy to talk more about. These are valuable tools, and it's not a time to take those tools away from the Office of Attorney General to exercise the discretion to do it. So that's, I hope, responsive to your question about how we think about exercising discretion.
Are you or is anyone else aware of any other jurisdiction that limits prosecutorial discretion in this way?
I don't know, when we say prosecutorial discretion, if you're talking about DPAs, they're entering into, they've charged the cases and that's how they actually count it, right? Is when they're saying that they've prosecuted 87%. Well, that's the young person's pled guilty. What they're not going to is sentencing. They're deciding what the sentence is without the court. So I would just point out, when we're talking about prosecutorial discretion, they actually have the discretion to prosecute the case or not, to paper it or not, to move forward or not. No one is talking about limiting their ability to prosecute cases. We are talking about what the available sentence is for certain types of cases. So I just want to point that out. And also when we're talking about separation of powers, the mayor has said this, and I think there's needs to be clarity that there are 3 branches of government: the executive, of which the Office of the Attorney General is, and is traditionally the legal representative of the executive, but it's getting fuzzy, like, and then there's judicial, and then there's legislative. So it's not clear which branch, there's no 4th branch. So if the executive is choosing to limit our authority, it's unclear, maybe we're in waters we haven't, how that we and the legislature are incapable of doing so. But I digress.
Okay, Attorney General, is that your understanding of the discretion component as it relates to just the sentencing, not whether to bring a case or not?
No, as I said in my testimony, there are a series of prosecutorial judgments that are being made along the way. So for example, decision to divert a case, which is part of the mayor's proposal, that's a question at the front end about whether to charge or not, to push into the prosecutorial process. The back end on a DDA is whether we're willing to, as a prosecutor, dismiss a charge, which is also part of our prosecutorial discretion. And I think that, the deputy mayor's characterization really is inconsistent with what happens on the ground in terms of how these cases are prosecuted. So you have a question of listening to the victim, looking at the individual charge, assessing the evidence, wanting to make sure that we think about swift and certain consequences, that we're thinking about what are the maximum chances that we get a child to accept responsibility. A plea agreement, accepting responsibility, is part of prosecution. That conversation that incentivizes a young person to engage in a DDA is part of what you've heard about during the hearing. What do they get out of that? They get immediate access to services. They get a chance to avoid having something on their record that could implicate their future, that could prevent them from going to college or getting a job. That incentivizes them to engage in programming right away, rather than an extended trial or appeal or process. And oftentimes that's what victims want. They want an admission and acceptance of responsibility. DDAs allow us to engage in restorative justice, which you know a lot about, we've talked about. That's part of the discretionary tools we have when we're trying to decide what's the best outcome for everybody involved. And so what the mayor's proposal is to come along and say, prosecutor, you can no longer do those things. We're going to prohibit you from certain prosecutorial choices in certain kinds of cases. And the separation of powers issue is the executive is asking the council, the legislative branch, to pass a law that ties the hands of the executive branch, which is the prosecutor. The fact that the mayor proposes the legislation it's the council that's being asked to pass a law, which I think would not be constitutional. And that's why I think you don't get there, because I don't think the data and the facts and the evidence support going down that route. But there's a very serious legal problem here in this proposal as well.
Can I just point out that adjustment was created by law? Adjustment, which is diversion, which is in the statute, was created by council by law. So council legislature kind of,
Yeah, I
creates
mean,
the
the
world we
council
live.
legislates things in the executive all the time. That's most of what we legislate. But I don't think we need to really get into that piece. So, General, I want to zoom out with you as well into kind of theory. You have made some statements in the past that we cannot prosecute our way out of crime. And we started to talk a little bit about this today with some of our public witnesses in the big picture in our city of doing a better job at getting services to people, preventing crime before it happens. But as our local prosecutor, what is your view on how you balance the potentially crimogenic effects or outcomes that could be part of a juvenile being in the criminal justice system with our need to deter crime and send a very clear message in a specific case and to the public writ large that things involving guns and involving violence are not acceptable, period?
I 100% agree that the level of violence and crime in our city is unacceptable. I've said it time and time again. And the statement where I have said that we can't prosecute our way out of crime is taken out of context, because what I've said before that is quoted is we are prosecuting every serious case we have that comes in the office. We do not divert gun cases, even possession cases. Even the compelling case story that you hear where a young person's carrying a gun because they're afraid of getting jumped. Those cases don't get diverted. We are recognizing the type of scourge of illegal guns we have in our city and the havoc it causes to our community. There is no more important thing to me and the people in my office than public safety. And so the cases that are most serious, that involve guns, that involve shooting, that involve people getting hurt, are being prosecuted. And they're not what we're talking about in this DDA space. We have seen more young people being committed into DRS, into secure detention. There are times when young people need to be in secure detention for the safety of the community. And not only are we prosecuting more of those cases, but the capacity of the system is stretched. So much so that the mayor had to offer up some emergency legislation last year for procurement expansion to be able to meet that need. So yes, we have to be prosecutors. We are the local prosecutors. And part of that is, in the right set of circumstances, seeking secure detention. And we do that. We ask courts to do that. We have extraordinarily talented defense counsel at PDS, which we should be grateful for as a community, that stand up and fight hard as to why that shouldn't happen. Sometimes judges agree with us. Sometimes they don't. In short, the system's working. But it is a false narrative that the AG prosecutors are not seeking secure detention effectively locking kids up for serious crimes. That's happening. But what we have to remember is that doesn't happen without costs. There are very serious costs to a community by over-incarcerating. And I don't think the mayor, the deputy mayor wants to argue for over-incarceration. I've heard them say that. But what we don't have a candid conversation about is the impact, the adverse impact of that from a question of cost, resources, and impact on families and kids. And so when we can find a way to get kids back on the right track and reduce recidivism, reduce crime from happening in the first place, without having the adverse consequences of pushing kids deeper into the criminal justice system, without the adverse consequences and trauma that being locked up at YSC and New Beginnings has on kids, even under the best of circumstances, we ought to try to make sure we're exploring that. And that's what we're doing in our city. And that's what the results of last year, when we look at some of the data of outcomes, is showing. So I think that in this context, and I listened closely to the deputy mayor's testimony, there's like 75, 80% of what she's saying that I think we're in violent agreement on. It's the question of why are we addressing this way when the evidence and the data and the practice on the ground is showing that things are working in terms of recidivism and in terms of success rates, and at a time when DYRS is not in a position by any fair account to take on more of the responsibility. And it's not just me saying it. And I'm not pointing fingers. Director Abed is there, and he and his team are doing the best they can with the limited staff and the resources they have. But his testimony about fentanyl overdoses in the facilities, about fighting in the facilities, about the short staff in the facilities, about the waiting list to getting treatment, all of that is his own statements to the council. So it's those two core pieces that I think are important for your committee now and for the council to think about. One is what's happening fact-wise with respect to the relatively small number of cases that end up being in this DDA, DPA consent decree prosecutorial use. What does the data show us? Is there something that needs fixing? And the alternative being proposed, is it something that the city can or should do at this point? And since I think both of those side against enacting this law, that's why I think the council shouldn't enact it.
I guess, Deputy Mayor, as we think about this DDA component in particular, is there a reason that is the piece that you are trying to address in this bill?
Yeah, I mean, so everything we've proposed over the past year, we've said is about being pragmatic. People keep talking about these relatively small numbers. If you're talking about hundreds of young people, those are hundreds of victims, and also they're also victims, the young people. So that's not compelling to us, even if we're able to impact this relatively small number. What we are focused on is, what does rehabilitation look like? There's been a discussion about recidivism. We don't measure recidivism in the district. So when we're talking about success of these programs, we don't even have a common definition. DYRS has one. A year after a young person's in the community, have they been rearrested? But when we're talking about whether programs are successful because a young person wasn't rearrested while they're on it, we don't know if that's, if 2 seconds later, or if they committed a crime and just weren't arrested. So we don't know that they're successful, because CJCC hasn't done long-term study on any of these programs that we're talking about actual recidivism. How do they do after? So that's the first thing, right? The reason we're focused is because kids with these most serious offenses, we will say potentially, we don't know, can pose the greatest risk to community for a host of reasons. We talked about this, we're talking about detention. No one's talking about pretrial detention. There's 166 committed youth. There's currently 40-something kids at New Beginnings. Much of the conversation about the facility is YSC, where the largest driver of our issues is our Title 16 youth. So that we're mixing all these different things, number of staff at the facilities. That's not really relevant to committed population. In 2012, when I started at DWRS, there were 950 committed youth. And you know what happened? The mayor and the council funded the agency to make sure that there was case management services. We can't say that an agency shouldn't serve young people who may need the appropriate, that at the deep end, need services because they're overburdened. You know what we do? Make sure there's more case managers. right? Like that's not, we also aren't talking about the capacity of court social services. We don't know how many people they have, but what I do know is this talk about 24-hour curfew monitoring, no, they don't. They don't. They will tell you that. They don't work 24 hours. They don't pick up a young person if there's a violation. We don't talk about what happens if a young person doesn't do any of these terms. 40-something% of kids didn't go to ACE last year that were referred. What happened? We don't know. Like what we talk about in CJCC is not a whole lot of anything. Our kids know that. The reason we're focused on that is because we have to start somewhere. We said we did truancy and we're like, okay, well, every proposal we've made, we limited it because we're like, let's talk about the kids charged with the most serious offenses. I will not sit here and act like we're charging young people with ADW because they hit someone with a pear. In our city, we've had 7 young people killed this year, right? Like we've had too many young people shot. That's what ADW is in the District of Columbia. Or stabbings. That's what young people are being charged with. We're taking on faith that CSSD is doing something that's providing them and their families with something that will help them to both help them, their families, and also keep the public safe. We're taking that is a lot of faith. While at the same time, we're talking about in the adult system, yes, we need to focus on those. Yes, we need pretrial detention, all of that. So what we're saying is if we believe in rehabilitation, we cannot simply take it on faith that CSSD is supervising, that agencies that have a hard time working together are going to magically work with CSSD. It's not working. The numbers, like to have a 3,800% increase in carjacking arrests over a 10-year period is wild. So when we're like, it's working, no, it's not. The community knows it's not, and we do too. And so that's why we're making these proposals to try and say the kids who are most at risk and quite frankly have committed the most serious offenses to us in the district. If you commit a violent crime or a dangerous crime while armed, that's serious. And we need to make sure there's proper supervision that is overseen by someone other than Congress and that there is some sort of service and some accountability for everyone in there being provided.
But if one of the problems is ACE, and you cited ACE, and the last numbers I read is that 54% of kids who are referred to ACE are not showing up. Why doesn't this bill seek to address ACE?
It does in the other part, right? Like so there's a discussion about what ACE was created for, right? Like trust me, we are having those discussions in the executive about ACE can't require people to go. It's a voluntary program. So the only way to get kids to come who don't come is there has got to be a referral over here. We talk about truancy. Schools don't make referrals. Nobody's taking it to court. So we have a whole system that is like, we don't want to do this. We don't want to criminalize, and that's fine. But we're not using the tools we have. Yes, ACE needs to be stronger. But what does ACE do as a voluntary program that was intended primarily for status offenses when it started for kids who aren't compliant? Well, if they're not compliant, then there's got to be a referral here. And if we're saying that, with all due respect to the Office of Attorney General, they don't want to move kids with violent offenses or otherwise deeper into the system, then what happens to those kids who are not being compliant here at the start of the system when we don't really have any consequence that we can impose to say, hey, you got to do this?
Okay, and I want to give you a chance, Attorney General, to respond to some of that. I also want to ask you, the Deputy Mayor started off by saying that we don't have accurate or complete data on recidivism and efficacy of these programs. How do you all measure the efficacy of your both diversion efforts, but then also the DDAs and the DPAs and the consent decrees?
I'm going to let Ms. Haggerty address it in a greater detail than this, other than I will say that we try to track both a rearrest number, which is going to be over-inclusive because sometimes you may have a rearrest, but there's not actually been an offense convicted. And then we also track convictions or young people being found responsible. And both of those are tracked over time. The success factor is when the program is in place for whatever period it is, 6 or 9 months, does the young person complete the program consistent with the criteria that are set out? One of which is always you can't reoffend. One is you got to go to school. One is you got to do the criteria that court social services and the court set out in the other kinds of cases that are not apparently the focus of the mayor's proposal.
Yes, Chairwoman. So I think, with all due respect to Deputy Mayor, because the Deputy Mayor has been forthcoming and very helpful to me, especially on violence interruption and engaging and talking there. But I think I want to be very clear about our use of consent decrees, DPAs, and DDAs. It's not that it's shrouded in mystery. So last year, February 14th, our deputy AG for public safety, for the Public Safety Division, sent a letter to the deputy mayor saying, you have asked us for our use of DPAs, DDAs, consent decrees on any gun offense, including possessory offenses. And so we said, we'll do you one better. We gave her data from 2019 to 2022. We had a little under 1,300 cases that we papered in 4 years that had a gun offense, 930 that we in fact petitioned and papered. Of that, 22% received a DDA. At that point, we said to the deputy mayor, we are happy to sit down, have a conversation with you and answer any additional questions that you have. OAG did a presentation to CJCC in April, and then an outcome of that presentation was the executive asked us for more information about our use of DDAs, including samples of those DDAs, how do we make a decision about a DDA, and what's included in those DDAs. And we did respond there. We did provide that those sample DDAs. And again, said, we're happy to talk to you about recidivism, doing an additional study and analysis whenever you're ready. To my knowledge, that meeting has never happened, and nor do I think we have ever received any additional follow-up. In terms of oversight and what we're doing on our DDAs, what that looks like and the outcomes, we absolutely have oversight, not just with the court, but before you, Chairwoman, and through CJCC, if there's any questions, especially during oversight. And so the only piece of information as it relates to recidivism rates that we have right now is from CJCC, which again, the AG has said that the mayor is a chair of, and that the deputy mayor is a co-chair of. And so when you're looking at recidivism, you do have to look at a longitudinal study because recidivism isn't random. When you look at it over time, it shows trends and shows you what rehabilitative programs are working and which ones aren't working. And so when you look at the recidivism rates for DPAs, DDAs, and consent decrees, they are arguably better, show better outcomes, which shows to me as a prosecutor, career prosecutor, that my prosecutors are making the correct decisions on assessing which cases deserve a consent decree, a DPA, and a DDA. And in this case, CDs, consent decrees, DPAs, aren't really even getting the dangerous crimes while armed, that option. And so going back to, recidivism, and we're talking about there, going back to what the AG was saying, we're doing this at a time. Again, it's not OAG saying this, it's the agency saying this. Yes, we have kids who are testing positive for fentanyl in our facilities. Yes, we have kids who are fighting each other in our facilities. Yes, we have a lawsuit. Yes, we have youths who have taken the key cards to get into secure facilities. Yes, some of our kids are having to sleep on cots in classrooms because we don't have enough space for them. Yes, we have not enough staff. In fact, I think it was somewhere near 40 staff were out at one point. That's what the question we need to address, what we need to be looking at before we try to say that these programs aren't working by every piece of evidence that we have in front of us right now, by the data shows that it is. So sorry.
Do not apologize. Thank
Yeah.
you very much. Really appreciate that. I want to turn specifically to Title I and talk about the kind of family engagement component. And so, Ms. Seminova, we heard from some earlier today about concerns about a mandatory family rehabilitation plan and concerns that it might be duplicative. I guess from your perspective, are there any kind of due process concerns with that suggestion, or why isn't more engagement of the family a good idea?
May I answer that? Is that
Sure.
okay?
Yes.
So I think my first answer to this,
Just make sure you talk into the microphone.
Sure.
The sound can't pick it up unless it's.
all right, being loud is not usually a problem I have, or maybe it is usually a problem I have. My short answer to Title I is the same answer I would have basically to this entire conversation, which is this proposed legislation shows a pretty profound lack of understanding of the way the system currently works. Parental participation orders are ordered in every single case at the initial hearing in JM 15. So the judge always has control over the parent to get them to participate in whatever services have been ordered. By the time a child is close to disposition, Court Social Services is already required by law to write a social study, which is an in-depth dive into the kid and the family and their circumstances and the charge. So the court already has all of that information too. This proposal on Title I is not an extra set of eyes or more input or more information alone. It is also a mandated plan that the court is required to adopt and required to order parents to participate in. And that's unprecedented in our statutes. We don't have any other place where the court is required to adopt a plan and substitute the judgment of an agency for that of the court. So that's really unusual and a violation of separation of powers. It is also true that this extra set of eyes that's been being invited in is a brand new set of eyes that has no contact with the kid or their performance or their compliance or anything about the case. So we already struggle in DC with having kids come in under the supervision of Court Social Services from the initial hearing, supervised in the field, in their homes, in their schools by a probation officer. And if that child is going to be committed, it's a brick wall, clean start with a brand new agency who doesn't know any of that information. That's already a little challenging for committed kids. This plan suggests that for all kids with serious offenses, which will be both a drain on DYRS and duplicative and probably not as useful as what we're already getting from Court Social Services. So the sort of intervention that's sort of the motivation for this already exists, and the court has the power to do it. Court Social Services has power. Government makes their own recommendations. There's not an additional need for DYRS, but it also requires enforcement of a plan developed by an agency that's new to the kid. And that's very unusual and
Okay.
I think legally insufficient.
So under current law and practice, what happens if the parent does not show up or if there is not compliance with the plan? What is the next step?
I have two answers to that. One, if the parent just literally doesn't show up, the court says to the probation officer, tell this mother that I can hold her in contempt. She's required to be here. Go tell her, because I want her to be here voluntarily and not because I'm having the marshals drag her in.
And sorry to interrupt, these are
course.
for cases that are at what stage of the process?
100% of juvenile cases that have been papered have a parental participation order. Okay. So if the parent doesn't come to court or won't make sure their kid gets to the probation office or participate in therapy, the court already has the power to force that parent to participate in the rehabilitation of their child.
And this is for anyone under the age of 18?
Anyone charged in juvenile court. So we could, in theory, have someone over the age of 18 whose offense happened before they were 18.
Okay. Okay, and you said two things.
Yes. The other thing I wanted to say goes to the point that the question you asked the deputy mayor earlier about early intervention and what is the mayor doing with other agencies that prevent these kids from ever coming into the system and meeting us, which is parents can only do as much as the city lets them or helps them do, right? Like I have access to medical providers for my kids because of my insurance. The parents that I meet love their kids and want to help their kids. And it's a constant struggle to access behavioral health and appropriate school. And, you know, parents have been through CFSA. So when we say like force parents to step up and that parents are tapping out, my experience is that parents are desperate for help from the city and they haven't been getting it. So I very rarely have a situation where there is a service that is available to the parent and child and the parent is willfully refusing it. Instead, what I have are crossover kids who have been in CFSA for years and the city hasn't done what they were supposed to do for the kid, or kids who are anxious and depressed and isolated and couldn't get anything from the Department of Behavioral Health, or kids who have been truant, you know, had trouble reading, didn't get appropriate intervention, started to be truant, are totally disconnected, and DCPS hasn't done. So there's a lot of tapping out here, but I don't see it coming from the parents. I see it coming from the city agencies, and those are the same agencies that are responsible not just before the kid gets arrested, but all the way through the case.
So Deputy Mayor, can you respond to that and from
Sure.
your perspective of what problem you think Title I seeks to address?
Yes.
Other than the CSSD kind of opaqueness.
So the one thing is when they're saying that it would be someone new to the case. No, what we're saying is that for these young people at the start have DYRS, right? If you're charged with a serious or a violent offense, rather than what Hannah, Ms. McElhenney said is correct, that prior to disposition, CSSD will absolutely do a social study. And likely if there's going to be commitment, I actually do know the system that there will be Woodcock Johnson and psychoeducational and any other number of assessments. What we're saying is that could be prior to disposition, which if a young person is released, disposition right now, even with it for speedy trial, we know this for kids who are actually held securely is supposed to be 30 to 30 days. But the court yesterday, as part of their budget submission to Congress, released that because of the judicial vacancies, that even for that, they are beyond that. So let alone the young people who are in community, which is who we're talking about, the ones charged with the most serious offenses. So how do we know? So if CSSD knows that disposition isn't going to happen for a year or two, and that's a realistic, that is not unrealistic, given the current volume of cases, the fact that there is very limited, there is a significant increase in juvenile cases and very limited assignments to the delinquency bench because there's no judges. So if disposition doesn't come for 2 years, CSSD also has limited resources. So that whenever the actual social study is done, could be way down the line. What we're saying is upfront, assess those young people and family, particularly if they're going to be released, so that we can start to, if there's a failure on the part of the agencies, which we talk about that, we've talked about that in here, that the agencies are involved at it's hard to know who's on first because the families have touched all around the system. I absolutely agree with that. So what we're saying is assign an agency to be responsible to navigate through that system, right? So that we actually someone's put on first to actually have a plan, right? That's really what we're trying to get at, is how can we early make sure that something is happening with the young person that we have eyes on with them and their family. That if there were 8 other failures, I can't control that, but by the time they've gotten to commit a violent offense or a serious offense or dangerous offense while armed, there's still something else that we need to do. And we absolutely, as the executive and as this government, need to be responsible for ensuring that's happening. So what we're saying is assess at the front end. Don't wait or rely upon predisposition for at some point. Because CSSD really does they have to prioritize as well. And their priority is going to be based upon who goes to disposition soonest. That, in all likelihood, is going to be the kids who are securely held based upon speedy trial, in theory. But like all of this kind of is variable. So we're saying, but those kids have serious potential risk/need. Let's assess them up front. So it doesn't have to be new people. If you're arrested, you may have touched before, but it may be you may not have experience with CSSD either, right? With probation either. So why shouldn't it be an agency that has, right, like responsibilities to do this for young people who are committed at the deep end? The crime isn't necessarily different. The needs might not be different. When it comes to DYRSs, we're talking a lot about the YSC and what's happening at the YSC, which is not really where primarily committed kids are. Like, so I can talk about staffing and all these things that people are throwing in. We absolutely need to look at our facilities and make sure that, they're substance free and that there's no incidents. That's a little bit of a red herring, because the committed youth or the young people that we're talking about, they're not at the YSC by and large. Like, there is an awaiting placement population, but I just want to say that because like people are like, they're overstaffed, they're understaffed. We're talking about secure programs. Like, we need to be talking about case management and those tasked with doing assessments, the pre-commitment units and otherwise, which we will staff based upon the need, because it's our responsibility to young people in the city and public safety, not to our agency staffing needs. We need to make sure that that's what the focus is.
Thank you. And,
May
sure,
I
go
offer
ahead.
just one last thing
Sure.
on the DDAs? Just from inside the system, one thing I just want to say is the most complicated kids, or maybe the kids who are the biggest threat to public safety, are not always determined by their charge. They're often determined by their compliance or non-compliance. And one thing about these DDAs is that they offer very fast intervention. So they get the kids who are really compliant, they're already released, they're doing well, off the most time-consuming track and let the court and the prosecutors and everyone focus on the kids who are probably the bigger threat to public safety. These are not easy agreements to get. Only my kids who are released and doing well are even offered them. But the incentive for a kid to still be able to apply to the military or Job Corps or college is so massive that I have kids who plead guilty to get these who otherwise would be in the trial chute for a very long time. And that actually, I think, has a negative effect on public safety because it means everyone has to get the same amount of time and resources instead of the higher risk kids. So thank you
Okay.
for.
No, thank you for adding that. And I hesitate to ask this because I think it is important to be focused on the data, and sometimes these anecdotal stories are the most extreme examples. But in being involved in this work for a while, I do hear, not all the time, but I still do hear stories of kids kind of bragging to their friends of like, come do this with me and there'll be no consequence, or I can get caught and nothing will happen. And so what is your response to that from the kids that you're working with? Like, is that overblown? Is that, why am I hearing that?
I think you're hearing that for a couple reasons. One, that's everybody's nightmare. So those are the stories that get told, right? Like that's sort of, I hear it amplified all the time, probably way out of proportion to how often it happens. Two, kids say ridiculous things that are not true. It's part of being a teenager that you say brave and untrue things all the time. These DDAs and DPAs are not the no consequences world, because if you don't do a good job, you get all the I mean, you have all the same conditions you have on probation. You had to plead guilty to get most of them. And if you do a bad job, if you're out of the house when you're not supposed to be, God forbid you get rearrested, if you're skipping school, the government just revokes it. You don't even get a probation revocation hearing. They just say, this is a risk. You are not abiding by these rules. We're taking this back. So it's not like if you get a DDA, it's a get out of jail free card. You don't get it in the first place if you were locked up. And if you don't do everything you're supposed to do, you're in the exact same position as a kid who lost their trial.
And who monitors that compliance?
Well, the child is monitored by court social services, but the OAG decides unilaterally whether they're complying or not. So we've had kids where they've moved to revoke DDAs for school attendance. And we're desperately saying, please not that, you know, it's the rearrest and more serious things. But the OAG, my experience is they are choosing kids who are very low risk, very high compliance. And if that's not working, they're right back in front of the court. So I'm often in the position of recommending a trial to kids because I think I can win, or I think the witnesses won't come and the government won't be able to prove their case. And the kids are like, I want the chance to get my record clear at the end of this. So I'm going to take this deal because I really think that I can do a good job. So the compliance, it's court social services with the backup of the OAG bringing these cases back.
Okay. You have anything to add to that, AG, of the kind of unilateral decision around compliance and follow-up? Okay. You mentioned in your testimony that you'll save your comments for Title I for discussion. So that time is now. What do you think about Title I? Why isn't more involvement from the family, more control, local control with our local agencies of being involved in follow-up at an earlier part of the case a good thing?
So let me start just kind of at the highest level. And I've said this before publicly. I hear from a lot of parents, a lot of families who tell me that they've been begging for help for their kids. And they scream out to their government when they need help. I spoke recently with a father whose son is addicted to drugs, and he's caught up in the beginning of the criminal justice system, and he can't get an appointment to deal with his substance use disorder for 9 months. So I don't see an epidemic in our city of parents running away from looking for help for their kids. I see just the opposite. So that's the high level of this. I don't know that I have anything really substantive to add to what you've already heard about this being duplicative, it being in excess. I mean, one of the challenges, you've heard this from other hearings we've been in together, is there is so many multiple dislocated agencies that families and children are trying to engage with that they burn out, that there's no coordination between them. And, you know, we have to do a better job on that. So now we're talking about adding still another agency. I think I like the idea, if what we mean at the front end, when the deputy mayor talks about the front end, is not when a young person is arrested by the police and papered by my office that they're starting to get attention, but really at the front end, when they're in school or when they're identifying health or trauma or drug or housing issues that we know contribute to delinquency. I like the idea of a comprehensive approach of our government getting to those young people and their families early. But I don't think that this is a solution generally to add another agency in, and especially not DYRS at this time. You have some other technical issues we can talk about, which is, we're talking about imposing a criteria on families before there's been a conviction. What happens if that case gets dismissed? What happens if the case, falls apart? What does that do for the requirement for the families going forward? But I think the larger picture for the committee to think about and for the council to think about on this is, is this the right solution? What are we trying to solve for? And is this actually going to advance solving? Because the idea that we throw more resources, we're just going to help families because we're going to throw more resources at them, is not proven itself to be an effective strategy. And we're in a resource constraint environment right now. So I'd like to see the limited resources that DYRS have be focused on the things we've identified in the Road Act, the things that we really want to focus on in terms of getting kids the rehabilitative services they need so that they don't return to crime. That makes us safer. That's what's going to make us safer in the long run. And so I think that's where I stand on Title I.
Thank you. This may be a Sagarty question, but can we zoom in a little bit on some of the breakdown of recidivism depending on the types of cases? So I'm curious in the, violent crimes overall for recidivism rates for juveniles who are offered diversion or alternatives to prosecution, and then for carjacking and gun possession cases.
Sorry, let me just make sure I have it down because I think we probably will have to follow up with those numbers.
Okay.
Update them from what we provide, I think, at oversight, to make sure I give you the most updated data, but just to make sure I have it correctly, Chairwoman.
One of the recidivism rates for kids who are diverted and get the DDAs and the breakdown of cases of overall violent crime, carjacking cases, and then while armed.
And when you say diverted, you mean ACE diversion versus?
Yes, at both of the levels of
Got it.
So diverted and then the DDAs.
And when you say recidivism, do you mean rearrest? Because again, like this is one of the challenges in our system is even in the CJCC report that was referenced, the 2022, it was tracked over the course of DWORS commitment plus 2 years, which isn't a normal, but DWORS commitment could be up to 21 and then 23. So some of the comparisons we're making is also tricky too, because if a DDA is 6 months, that's not the same as 7 years of tracking whether anyone's arrested. So traditionally DWORS used the timeframe of 1 year from a time a youth is in community. So that means not in a secure facility, whether here or otherwise, post 1 year after that. So even if their commitment ends and they were put in community 6 months before, recidivism would be basically 18 months, right? Because it'd be 6 months plus a year after they hit community. So we have these definitional challenges that kind of help us to, quite frankly, like say anything about recidivism. So I just want to clarify, are you talking about rearrest or true recidivism, which is they don't reoffend at any point in some extended period beyond just the program, right? Like, so you start to compare apples to oranges, but I point that out because even when you're looking at commitment, which is multi-year, were they ever rearrested during their 4-year commitment? Were they ever arrested during 6 months? And then we're saying one is better than the other. I don't know if that's actually real, but we need to define what we're saying so that what we're actually tracking. And this is something that CJCC, the Juvenile Justice Subcommittee, have worked on for years to try and get everybody to do like the same definition so that what you're talking about is real when you're comparing programs. And so that might be a space where they had done a lot of work either through the JDI, through the data committee, the juvenile data committee or otherwise. But I put that out there because rearrest is not the same as recidivism, and the agencies need to be tracking the same to speak the same language.
Yeah, I hear that. I mean, and frankly, I think from OAG's perspective, we need it in how you track it in terms of a new matter. I think from a citywide perspective, what really would be more effective is to figure out compliance, showing up at school. Like, these are things that are outside of the jurisdiction of the Attorney General's office, but if a child, whether they're going to be, recharged again or not, if we have over 40% of our kids not going to school, like that is unacceptable. And that's why I'm happy that this conversation, this bill meant to address some of those larger patterns, and given our limited committee structure, they're bifurcated, but it is a huge part of the conversation. Certainly not every kid who doesn't go to school is engaged in violent crime. I'm not suggesting that, but there is a relationship in making sure that our kids can get to school safely and have a requirement of showing up and a follow-up if they're not showing up. And whether we are gonna frame it from the perspective of parents need to do more or parents need more support, both could be true. But we are missing the mark when it comes to that follow-up.
And can I tell you, one of the challenges we have that we're talking through and we is, you have this idea of what educational neglect is, and that's part of the problem, right? Is that CFSA, who is primarily tasked with a lot of it, right? Like, the reason there's even a shift to DHS, and I know we're not getting to this, is because some parents view CFSA as enforcement, right? And CFSA in some respects view themselves as enforcement as well. And that is a very different role than your child isn't going to school. Like, let's see if we can work together to figure out how to get them in school because we're concerned. And that's been sort of the diversion, is that DHS is a little bit more neutral in that space, whereas CFSA is an enforcement agency, right? Like, they are. Like, so I say that because when we were looking at all of the reason the bill is kind of what it is like, we're like, all of these pathways have to change. And then the fly in the ointment of all of it is CSSD, because even for chronic absenteeism, they play a critical role, but you have, executive CSSD who may or may, right, like, who may or may not engage with DCPS or whatever is going on. There's a host of things, but that's why it was the through line through, is how can we make sure that there's more accountability for the executive, quite frankly, and an oversight of what's happening with these various cohorts in a way that is going to both upstream support families, but also once young people commit crimes. And I don't want to sound mean, but like, there is we do have a responsibility for public safety as well in all of this, and that we have to think about that too. And so it is about the young people in rehabilitation, but there also is a piece where it's like, and protection of the public. So we really have to start looking at some of these things from that lens too.
PDS and OIG think CSSD is doing a good job.
Small wrap-up question. I would say sometimes very much yes, sometimes very much no, and all the way along that spectrum. I think Court Social Services runs excellent evaluations, psychoeducational, psychological evaluations of our clients. I think that some probation officers are really suited to the job and good at it. I also think that our Court Social Services division operates from a law enforcement perspective more than an obstacle reduction perspective. They don't see themselves as social workers or problem solvers as much as they do as reporters of problems that exist. So I would want that to be very different. That's what I would say. I think that they definitely do more than DYR's caseworkers do in terms of knowing the child, knowing their family, visiting their homes, visiting their schools. Like, they're very present in the community for the whole pretrial process. Yeah.
I think I agree with Ms. McElhaney's assessment. My understanding is that oftentimes it really depends on the particular probation officer that gets assigned to a case, and you hear some extraordinary relationships and effort being made by some really, really good probation officers that work and have worked for a lot of years with Court Social Services. It's not necessarily every case that has that type of outcome.
So Deputy Mayor, I want to ask you a little bit about some of the specific language on how the family rehabilitation plan would work. Like, what does that really mean, and who would be in charge of ensuring compliance? If a rehabilitation plan includes follow-up meetings, again, what happens if they don't, or who's really monitoring?
Yeah, so I mean, it's tricky, right? Because the monitoring becomes the court, like the implementer, DORS becomes the linchpin agency that's responsible. But ultimately, like it is a team model. So if the family has involvement, first of all, like part of this is to figure out where all of the involvement is, because it's, again, very rare that there's a family that does not have touch points somewhere. And CSSD, while they do family group conferencing, it's very difficult, and we've talked about this, to have all of the agencies who they have no authority over and who we have no real authority over them either, to come to the table to determine what is going on with a family. So it very well may be that a family already has, their child finished STEP because they were a chronic runaway, but because they then got involved in the juvenile justice system, now they no longer enrolled in STEP, which is an ACE program for chronic missing young people, right? They may have a CFSA case where there were several touches, but they currently have a closed case. They may have things going on at school, right? Like they have had some issues with school, and and we will be able to know all of that with, like, we know it now with our critical incident, but somebody has to be on first. So what we're saying is, for those young people, even if they never make it under the supervision, the mayor has said this and it's true, it's very difficult sometimes to make people do something if you can't make them do something. And that's why why we've said we want them, but
what happens if they don't do it? I don't see any
and the
language in
court,
here.
so I mean, the court, it's part of a parental participation plan. So the court still has the remedies available to them of both civil contempt or to issue a bench warrant, right? Like, so the youth is still in the delinquency system. So the court still ultimately has the supervision over the case, or I don't know if you want what you would call it. Like, you could call it supervision, right? Like, it isn't different than if court social services, everyone's saying there's parental plans now, right? And that the court already can make people do things, right? So what we're saying is, well, there should be an executive agency that's doing an assessment. CSSD, I'm not questioning their assessment. I know they do KZs, they do all these different things. What I'm saying is, they may or may not get DBH to actually to work with a core service provider to make sure the family is actually able to get the services they want. We say that for people involved with ones, that they're critical, that we believe they're most at risk. So it's incumbent upon me to make sure all the agencies come to the table and get them what they need, which is what we've been working to do and how we're seeing reductions. Why aren't those young people? Who are the young people that we believe that? Well, one group that we can identify is them. And so why aren't they getting that same teaming service from the executive, with someone being responsible and an identification of those young people at the start of their process with the criminal justice, or wherever they are in the juvenile justice system? That's really what we're saying.
If I may, this process doesn't really make sense because, doesn't really make sense because it's asking DYRS to create a treatment plan that DYRS will not monitor or enforce, and the judge is obligated to enforce, but the judge didn't choose. So already we have Court Social Services, who is the entire case, having family group conferences, coming up with a treatment plan, recommending services, and if that child stays on probation, Court Social Services has to do what they said the child needed and provide the services. And ultimately, all of the services are these same city agencies that we're talking about prevention, and then we're talking about supervision, and then we're talking about if the child is on probation. So if there is no inpatient hospital for the child to go to, it doesn't matter whether DYRS recommended it or Court Social Services recommended it. There's no place to treat the child. If the child can't get grief therapy because he's seen a brother be killed, it doesn't matter whether DYRS recommends group therapy or Court Social Services recommends it. If the city doesn't provide it, we aren't getting it. So to me, the idea that DYRS would come in, evaluate the child and family, say, this is a plan, this legislation requires the court to adopt it, and then enforce parental participation. but then DYRS doesn't monitor it or provide the services themselves, it just doesn't, it's like not a workable solution. You already have an agency that does this. And the gap that we've been talking about this whole hearing is, where are the actual services? Are they available, and how long does it take to connect the kid? If they exist and the kid can be connected, you already have a system where there is an agency identifying them, asking for them, the court mandates them, and the parent is required to participate in them. That exists.
But it's not our agency. Like, so the thing is, there's no responsibility, accountability, or otherwise for court social services. Like, if people have a different plan, then we're very open to that. What we're trying to do is say that we have a responsibility to do something here. That people are like, it all works. That's what I'm hearing. But the community is very clear that parental accountability, it's not working. It isn't. What we're doing isn't working. And the executive is open to suggestion, right? Like, just like we said last year, we'll put something on the table if people have a better idea. But to say that there's an agency that just does this, but they can't access services, yes, that's why we said we should merge CURE with ONES, because someone has to be responsible. DWRS will be responsible. If the child moves to commitment, DWRS has to come in at pre-commitment phase and do all of this anyways, and will be responsible for ensuring that all of those services are provided. We've spoken multiple times in multiple ways about navigators, that part of what families really need is a navigation through the system. And the mayor's asked us, who should be the people navigating? Is it the schools? Is it DHS? Right? We're like, well, there's different points along the way. Up above, we said DHS should be, right? Earlier, that's why we did the truancy. But once a child has committed a violent offense or a dangerous crime, we say DYRS, you can love it, hate it, whatever. It is the deep end of the juvenile justice system, and that the young people committed many of similar types of charges. So perhaps they are the ones who should be responsible for ensuring that that cohort of young person is assessed and that the families are provided with, or at least we know what they need, right? They do it down here, but they're like, they shouldn't do it up here. CSSD does it. They're not under our I don't know what CSSD does or doesn't do. I'm not saying whether they do or don't, but I do know none of them are accountable to you. They're not accountable to the mayor. They're not really fully accountable to the residents of the District of Columbia. So like, we gotta get
Yeah.
some more visibility here.
Okay, no, thank you. Thank you all for that. And it's gonna be my last question. I kind of started with the deputy mayor asking what problem that the mayor is trying to address here. And as I often say, hopefully all of us in government are in the solutions business. And so I appreciate looking at a problem and trying to move forward something to fix it. I have heard a lot of today of this is happening or this is working. So as we look at the crime trend numbers, as we look at juveniles being involved in these violent and dangerous cases, that we all want to put a stop to, period. We need to do more on the services side. I'm hearing that both at the early end and at the CSSD end. And so we'll do everything we can to kind of continue urging that and working with the executive on that. But as you look at the criminal justice piece of this puzzle, what gaps do you see that we should be seeking to fill? If not these ones, then how can we tighten up the system to make it more effective and to see the outcomes that I know we all want to see when it comes to our kids? I am.
Well, as usual, Chairwoman, you ask a question that, may be impossible to answer in sort of short form. Our office has to do its job, and it is. Our job is to look at each case that comes to us from MPD. We can't deal with crimes that never get closed. There's a lot of carjacking incidents that happen in our city that don't result in arrests. We got to do a better job of closing cases. Prosecutors can't address cases. We got to make sure that when the cases come to us, we have the right kind of evidence that's admissible, that's credible. We've talked about DFS and being a piece of the overall ecosystem. We have to recognize that families need services, kids need services, that we can't find our way out of some of these issues that are recurring by just having a conveyor belt process of dealing with families and kids. All of that is part of it. But when you do get into the criminal justice system and you have evidence that a violent crime has occurred with a gun and that person is a juvenile, the Office of Attorney General is prosecuting those cases. That's our job. And sometimes you have a child who is prosecuted and committed to DRS and goes in and is committed, and they come out and they commit an offense again. Or they move on to being an adult and they go into the adult system and they commit crimes as adults. That doesn't mean we have to stop doing what we're doing as prosecutors. These cases that we're talking about for this legislation, the focus of this legislation, we're talking about prosecutorial tools that we use sparingly and prudently in the cases that warrant them. There are positive things to say about that tool. And based on the data, and I agree with the deputy mayor, could the data be better? Could the city all agree on how we're going to track this data? This was part of what we suggested a year and a half ago in terms of having a conversation. I'm all in on that. I'm also all in on working with the mayor and figuring out which agency in our city is actually going to figure out how to answer the cries of the parents that I hear about they don't want their kids arrested before they get the kind of psychiatric needs and the health needs and the educational needs that they have. I'm all in on that. But where we are today on this bill, on this proposed bill, just the titles that we're here to talk about, is we're doing the DDAs prudently and sparingly. And the results that we do have show that they are working. The anecdotal evidence you've heard from the hearing today shows that they are providing opportunities for young people and families that they don't otherwise get with other types of routes and options in the system. That's not what we need to focus on changing right now. I agree with the deputy mayor that I would like to see greater transparency in our federal partners. I agree with that. There's not going to be a debate on that. But right now, where we are in our city, and it being the highest priority of, I think, everybody in the executive branch, the mayor's team, my team, to focus on public safety, your committee and the council's focus on public safety, pushing more kids to DRS right now is not a good solution. There isn't data to suggest it's a good idea. What's happening, we'd be turning a blind eye to what's happening in our city right now to be pushing more kids and families into DRS right now. So let's keep after it. Let's keep talking about how we're going to do these things. But this part of the solution, I don't think advances the ball. I think it would set us back. And that's why I would urge your committee not to move forward with these three titles that we've talked about this morning.
If there was anything else to add on that?
Please. I think what I would just say is I am a real believer that no kid is born destined to end up in this system. And I am a real believer that this system has the obligation to change trajectories for kids who come in. We are not the criminal justice system. This is not about punishment. It really is about making sure this kind of thing doesn't happen again, both for the community and for the kid. So I think the entire question is, how do you see each kid as a particular individual with needs, and how do we meet them? And sometimes that looks more like a residential treatment facility or a more serious high-level intervention. And sometimes it looks like a tailored plan to say, I see you doing well and I trust you to keep doing well. If you do that, you can have a benefit. I'm very leery of responding to crime with some action without knowing that the action will change trajectories and make families and respondents safer. So I would just say, I think we're all trying to do the same thing in the room, which is not have these shootings, not have the mothers that testified earlier ever come in circumstances like this. But to do that, it has to be a question of how did this kid get here in the first place and how do we get him out? And that I think is the whole focus of all of this.
Well, as this was your bill, the executive's bill, Deputy Mayor, I'll give you the final word if you have any closing thoughts.
No, I would just say this, that we're committed to the same thing that we've been committed to the whole time, to solutions that help make our families, our young people, and our community safer. That's the key thing. And that, you know, we will always say, as the mayor said, we have to really take a hard look at our system, and we have. In the adult system, we've made some adjustments and we've seen some progress, and it's not perfect, and we'll continue to work together on that. I think, you know, we're here looking at our juvenile justice system, which also it isn't working. We have to make some adjustments. And I think we would all love the luxury of knowing what's going to happen before we do it, right? Like but we don't have that. And so I think what we're trying to do is work with the data we have to work with the resources that really are under our purview and not we would love to we would love to be a state. We wouldn't have these issues, right? Like, but there's a whole host of things that we still can do together. You asked me, I don't know, maybe it was the round table. I'm in here a lot with you. What we can do, I'm like, these are the things we can do together to really continue to look at the spaces where some adjustments absolutely are necessary because the outcomes, whether we want it or not, are not what we want them to be, either for our young people who are being shot and killed too much, or who are finding themselves involved in serious crime too much, and for our community. And so that's what we're committed to, continuing to come back to the table to work it through and figure it out so that we can make our city safer.
Well, thank you. Thank you all very much for being here and for engaging in a fruitful discussion. I fear I have more questions than perhaps I began the day with, but that's the work that we do. And so look forward to continuing our partnership with all of you as we do, as I said, what I know is our shared goal to drive down crime and to keep kids safe across the spectrum. And like with the executive agencies, sometimes being under one cluster, one silo, we struggle with that as well at our committee. And so we'll keep trying to fight against those barriers because the truth is people are holistic and these challenges are holistic and not in a silo. So I appreciate all of you continuing to be leaned in with us as we seek to get this right, both in the short term and the long term. And thank you so much for all that you all do for our city. With that, the time is 1:21 p.m. on Thursday, May 30th, and we are adjourned.